on there, www.nvndpc.com. We sent out our schedule for a year, which was very entertaining to hack out. So if you've got questions, check it out, sign up. We're doing a mixer in the springtime, so that'll be nice. This cold air will be gone. Membership, we always appreciate that. We are a 501c. We do need money all the time. And so your membership supports us in that. It also, we are working on being able to provide you more benefits with that. Stay tuned and see.
You did it.
Well, it's not on Teams.
Matt
Oh,
did.
it's not on TV.
I figured we should have it
Oh,
here.
yeah,
Yeah.
we have three sponsors. What is that?
Whoever's not muted,
heavens have opened.
mute your mics online. Whoever's not muted,
It's an option.
mute your mics online. Whoever's not muted, mute your mics online.
We're caught in a loop. We're caught in a loop. I see this in Interstellar. This is the rest of eternity.
Maybe it's your computer.
It probably is.
Are we good?
Can you hear it?
All right.
That means we might be in.
There's always a moment.
I know, right? Yeah.
Always a moment.
Earlier we were all echoing, so yeah, it was,
that's bad.
it was super fun.
Hey, thanks so much for our sponsors. We have Streamline. Who's Streamline?
Streamline, Mark Boehner, the one that came here last time and spoke.
Oh, yeah. We liked him.
Yeah.
Hand Center Nevada, thank you very much. And Center for Wellness and Pain Care, right on. Always open forum, ask it. Someone's thinking it, so ask it. Don't be afraid. If anybody says anything about you, I'll take care of it. Intro to the panelists. Oh, my two favorites. We have Senior Kevin from Shook and Stone and Sean Ming. So, is it light for a reason? Kevin joined Shook and Stone. Look, she's changed yours a little bit.
Oh, she.
Has joined Shook and Stone in 2014. Kevin brings professional experience as well as a significant litigation experience. Kevin is experienced in workers' compensation and criminal defense. He is a managing attorney and division head for workers' compensation and the criminal defense.
Now I'm a partner.
You're what? Now a partner? He's
I told her to change that part.
Oh,
No.
he told me at 8:55 this morning to change that part.
Kevin is currently
I
a
know.
partner at Shook and Stone. That's outstanding.
Right.
Okay,
That's on.
echoes on.
Yeah, that's
Move on.
good.
Yes.
We can see it and everything.
Yeah, that was good. Yeah, look at this. Perfect.
Well, I think it's sad. There's like 3 paragraphs for Kevin, and then she's got like 4 lines for you, Sean.
No,
Yeah,
that's because she
it's no
used
big
an
deal.
old bio of
There's
mine.
another page
Jo-
for
hey,
Sean.
hey,
Don't even-
Hey,
And
don't
we
worry,
have a
don't worry. I'll
joke,
make up for it.
He will, yeah.
You got pictures for
He has a
me.
slide for himself. Yeah. So, right.
Yeah, you'll see some. There you go.
There you go.
No description
There we
necessary.
go. We got baby Sean.
Man, Sean Ming is a founding partner of HMC. Law Office represents defense for compensation, workers' compensation, determined administration, hearing subrogation litigation in the states of Nevada, Arizona, and Utah. Wow, you're still doing all of them?
Yeah. Actually, we just reactivated in Utah, so
Wow, congrats.
it's exciting.
He also handles civil litigation that relates to the insurance, industrial insurance, and employment. He's awesome.
Yeah.
He really is. He's awesome. He's got like a whole page of it.
I told you. Oh, now
I
the
saw-
truth
I
comes
didn't
out.
see it.
It's like an
His own
ongoing
page.
joke.
The truth comes
He
out.
had his own page.
I'm
And it
sorry,
says
you list
blah,
4
blah,
lines.
blah, blah, blah,
got
blah,
pictures.
blah, blah.
You know what we do. Yeah. Right.
He's like, this is hilarious. That was like
Out of control.
that was like a bait. Is what that was. I was like, don't worry, I got pictures. You're like, oh, actually, we got 3 more pages. So thanks for bringing the pictures, Sean.
Yeah, that's exactly right.
You must think pretty highly of yourself.
We love these guys. We appreciate the fact that they do this every year. If you guys have questions again, let us know. Okay.
Yeah, one of the other things that's interesting is I know that Kevin practiced for a number of years in criminal defense,
We just
And,
had
um,
that conversation.
Still does,
It was
no?
amazing.
And do you do criminal
He
defense
dabbles.
still?
A little bit, yeah, not as
Only
much
when the
anymore.
workers'
but-
Where do you get the
adjusters
time,
get
yeah.
arrested.
Right, exactly.
not
yeah,
them.
Yeah.
Yeah,
Only
yeah,
for
no.
friends? No, that's
No.
it's the
No,
worst.
I can be much more selective on who I represent.
Right. Oh my gosh. But and then
Family discount, just so you know.
I actually got my start in criminal defense as well. I don't know if Kevin knew that, but I worked at a firm here in town while I was in law school under the student practice license, and actually ended up doing an attempt murder trial, basically by myself, which is not supposed to happen. But my supervising attorney was next door doing a trial, so that was good enough. But some of the things that we'll talk about today.
The person went to jail. He lost. They went to jail.
Well,
No.
well, we beat the deal, but he still went to jail.
But that's, yeah, I mean, that, an attempted
So-
murder
Right,
charge.
exactly. It's not bad, right?
Someone's going to jail on attempted murder, even if you plead out.
Right, exactly. So, no, some of the things we'll talk about today, we'll draw from our history, from our own experiences. And I know that some of you have been here before for this. We want it to be we're hoping that it becomes a more and more open forum. So we get less of our, kind of anecdotal stories and more of your experiences in the industry. So feel free to interrupt when you see something that, oh my goodness, I just dealt with something like this, or, oh, what am I supposed to do when this represented worker calls me up and tries to, get an appointment scheduled or something like that. So just jump in. I guess just for starters, here, Christy's not at her computer, so we won't know what the comments come in from the web. But who has dealt with recently some sort of an ethical dilemma, either in your personal administration of claims or in with opposing counsel? That's brought some. You want to share, Sandy?
So, as a claims adjuster, when an employee asks you, or one of your claimants asks you, should I get an attorney? My ethical training as a claims adjuster was, you can never respond to that. That's a personal decision, and you'd have to defer and tell them you can't do that. I got a call 2 weeks ago from a supervisor who said, 2 of our employees were hit by a drunk driver out at the job site. They want to talk to you about what the ramifications are if they get an attorney. And now I'm an employer, and I'm thinking, well, am I really bound by the claims adjuster response, or as an employer, do I give them an educated response? And so,
That's a great one.
and they're graveyard employees, so they made a special arrangement to call me at 8 o'clock at night, and I really was kind of torn, because they're always told to ask me
Right.
about claims questions. And so I basically told them that, I showed them the statute, I gave them a copy of it, sent it to their email, and I told them that whether or not they get an attorney has no bearing on how they're gonna interact with me as an employer, but it may impact their ability to interact with the adjuster, and I deferred them to meet with an attorney, talk to them about workers' comp, talk to them about the personal injury component of it, and make a decision. So I really didn't know what as an employer, what my boundaries were.
That's a perfect example, because what you're looking at, when I was much younger, before I went to college,
Come on, you're 11
me and
now,
I mean, hey, listen, hey, this is a big year for me. I don't know if you know.
You didn't turn 30?
I'm turning 20. No, I'm just kidding. No, this is a big year for me though. So I mean,
Yeah, 40.
it's not, yeah.
Yeah.
40.
Yeah,
Look
but
at you looking
shoes
at that
are
like it's
here.
nothing. No
Yeah.
big deal. 40 years is an accomplishment. It feels like one at
For
least.
you. And
Nobody
your
thought
mother.
I'd live this long. Let's
And
be
your
honest.
mother.
You can all believe that. No, but so we used to go out to these caves, and there was one specific cave that had a very small opening, right? But if you could make it through that opening, like you literally had to like squeeze through it, even as a young kid. And if you made it through that opening, it opened up into this huge cavern, right? And I'm sure that you've all seen, pictures of that
And a
type of
scary
situation,
movie.
where very scary movies where they talk about that stuff. But that's exactly what you're dealing with here, right? You're at the very inception, but what you don't know is all of the ethical issues that come behind it. So I'm sure that Kevin started counting them up. But you're the employer, right? So you actually have a vested interest in whether or not they pursue a third-party claim, right? At the end of that third-party claim, you have a vested interest on whether they have an attorney or not, right? And because under Brain, you might be paying for some of that attorney. You also have an interest in whether, that you file before they file. So all of a sudden, there's this huge conflict that exists, right? Even aside from the direct work comp conflict that you have, right? What should we do? Should we get an attorney? Should we file a claim, right, for this? And it might seem very easy to just off the cuff be like, well, yeah, you were hit by a drunk driver. Of course you file a claim. But now you're giving some legal advice, right? And so what seems like a very easy issue, especially for you wearing two hats as an employer, right, with all of your training, in adjusting claims, it's not so easy, right? And that's sort of the reason that we do this training. And I think it's the reason why the Division of Insurance requires you to do this training every year, to get these ethics credits. But what do you think, Kevin? Just from the onset here.
I love that first example because you could, if you were in her position, you may have made a different decision. Okay, so a lot of times there's no manual on how to conduct yourself ethically, and opinions will vary. And one of the things, when we're doing ethics, Sean and I are going to talk a lot about legal ethics because that's what we're bound by. There's different ethical obligations you have as claims adjusters and in other industries. But that too can be different because you are conducting yourself, and this is where, although an area we have probably underlying broad agreement of what our ethical obligations are and what we should or should not do. But that thought process is very, very different, and there's not necessarily a right or wrong. I remember the first time we did this, I was, that's one of the reasons why I'm involved in this group is I share some of my practice points. My colleagues do not with all of you, but I do. And there was this kind of like discussion. I'm like, well, I do that for me because guess what? The 1,000 people that I represent, it's my ass, not yours.
Yeah.
So if I have my practice structured in a certain way, service of process, how you communicate, all of those types of things, then that's my prerogative, okay? And sometimes I will say, and I don't want this to sound rude, but sometimes I see, and I call it the self-important adjuster, where the adjuster thinks that we do the same job, and we don't, okay? And we have very, very different ethical obligations, okay? But I love this example because you should pause, and you should be torn of, what should I do? And maybe you'd consult other people. I mean, then that comes down to us with confidentiality. I mean, there's stuff like that. So it's an ongoing discussion. And I think, now, I loved your answer. But that's me. You know what I mean? So he may think, well, that answer sucks.
Well, and you freak out.
Some people are coming on late and they don't know the question. Sandy, can you
Okay.
repeat the situation real quick so they know what we're talking about? A lot of people are coming on.
And can we confirm that they can hear Sandy over there, just so that we?
I think everybody can
Okay,
hear.
good. I just want to make sure.
So, as an adjuster, if an injured worker asked me if they should get an attorney, I would have to tell them that it was unethical for me to make that, for me to respond to that that's a personal choice. However, as an employer, I had 2 employees who were struck by a drunk driver while out on a job site, and they filed a claim immediately, but their next question to their supervisor was, should they get an attorney because they were hit by a third-party drunk driver? And his supervisor made an appointment with me for an 8 o'clock conference call to have a conversation with them. And so, as an employer, I was torn. I knew exactly what to say as an adjuster, but as an employer who's supposed to help the employees through the process, I was torn as to what I should be saying.
So can we talk just a second about that adjuster? Because I just want to make sure, Dalton talks about the fact that we're now in 2.5, adjuster 2.5, as opposed to 1 point, which is us old people.
Moving on to 3, right?
We actually are moving on to 3, exactly. So can we address that? That an adjuster does not say, I don't care, go get an adjuster, or go get an attorney. They don't say, yes, I think Kevin's a great attorney, you should go see him.
Despite the kickbacks, no, I'm just kidding. That's a joke. I'm not accusing anybody of anything here. That was a joke. That was all a joke.
Bad joke,
It was a
right?
bad joke.
There might have been some in the 80s.
No, yeah.
So, I want adjusters to appreciate the fact that when the attorney goes, when the injured worker says, I'm gonna go get an attorney, or should I go get an attorney? Your response should be canned, and it should be exactly what what's your name again? Sandy. Exactly.
What's her name again?
Do you guys just meet? You're just meeting each other for
Yeah,
the
we're
first
just
time?
meeting. It's exactly what Sandy just said. You should never have a sentence longer than what she said. It's a personal opinion. You need to make that choice.
I think that there's certain things that you can say and that you can't say, but we'll get back to the example probably as we go through today. It provides a good base for what we talk about in real life examples of it. But I mean, it's interesting because you look at Sandy talking to them, and you're probably like, oh, the employer should guide them, right? Because that's what an employer is kind of there for. But if you then switch the hat a little bit and you say, okay, Sandy's asked Sean to come in and represent the employer. I'm still just representing the employer. But then you're like, oh, should an attorney advise them on whether or not they should get an attorney? Like, oh, that doesn't seem fair, right? And so you start to change the hats around a little bit, and you realize, oh, there's more packed into this than what kind of meets the eye. For attorneys, they realized that a long, long time ago. One, that many of us didn't have a moral compass to rely on, and two, that it just wasn't that easy to where you can go with what mom and pop told you when you're a kid, right? And we just didn't have the angel and the devil to guide us on what to do on these because once you start putting on somebody else's hat and taking a role where you owe a duty to that other person, which you do as the employer, you owe a fiduciary duty to the employer itself, the company that you work for, the shareholders, all that. You probably owe some duties to your employees, right? And once you start shifting that burden around as to what you can and can't do and who you are beholden to, it just doesn't become very black and white. And that's the reason that we hope that you'd take this serious. We hope that you'd be open, and that if you have concerns about these things, that you open up and talk about it. And I know that there's issues that each of you deal with in regard to legal ethics and in regard to ethics in your jobs on a daily basis. Even though we might not see them, and they might not be as cut and dry as some individuals who are hit in a drunk driving accident asking you directly if they should get an attorney. You do deal with them. Most of them you just handle the right way just because it's an easy decision to make. But there are I'm sure every day there's some that you kind of straddle that line on. We already told you a little bit about ourselves. You're going to see a couple pictures about myself here. One of the things that I try to have be the theme of this, and for the last 4 years I think we've been doing it. For the last 4 years I've been trying to teach is that the dialogue that just went on between Sandy and Kevin, right? It's easy in this room to recognize that we're people, right? Those who are participating via the web, harder for us to see them as people, sadly. Sorry, everybody that's out there. But it's harder because we don't have them right here in front of us. We're not interacting in person. Turn that into a telephone call that that you have the power to hang up on, right? Even more difficult to realize it's a person. Turn that into an email with somebody you've dealt with in the past. You're moving that scale. Turned into some faceless person who just has a C4 form that's in front of you. Even more difficult. They start to just turn into data. But it's important as we participate in this, what's becoming more and more litigious, more and more adversarial environment all the time, to recognize that we're dealing with people, and that people make mistakes, and that people have feelings and are emotional, and even people like Kevin are emotional and have feelings. No, but people are emotional, and people need a little bit of grace every now and then. And you probably need to give yourself a little grace, in dealing with these kind of hot topics, right? I know that I talk to more experienced adjusters and less experienced adjusters, in and out of the day. And I'll tell you what, it's refreshing to talk to the brand new newbies, because they look at things like death claims, like totally different than like Kevin or I would, right? Or that you would after seeing so many of them. They look at a back strain, just simply walking across the office, different than we would, right? Than most of us would that have been experienced in the industry. And it's important to sort of recalibrate yourself so that you're dealing with these claims in the proper way, right? So the best way that you're responsible to your employer or to your administrator with, but also to deal with them in a way where that we remain, human about the issues. And that becomes difficult too. To demonstrate that, I'm also a human. This is me, a picture about 10 years ago now, which is sad to say. I was
Back when you were young.
back when I was young, just a young buck, all those dreams in my eyes and hopes. But I have a family. This is my wife and I. We love to travel. We go. This is us in Ireland. A couple years ago. I have 5 kids. Right. So I'm busy with 5 kids. It takes up a lot of time. I went to.
I'd say
I had
you're
a
busy.
oh my goodness! I knew it was coming. Kevin has the restraint to just give me like an eye.
Yeah,
Of course,
no,
you gotta
no,
put it
we
right
have to
out
put
there,
it
man.
right on the road.
But no, I mean we had a 3-day weekend, which was great. I mean I'm never off the clock or anything like that as a business owner, but we had a 3-day weekend, and one of my kids had 6 soccer games this weekend, so very, very busy handling work from the tournament that he was in. But I also love the 49ers, and
I have 5 kids.
yeah, 49ers, yeah. I may or may not be wearing, and Kevin can.
Oh, yeah, okay.
I may or may not be wearing 49ers socks right now.
Nice.
We're playing the Cowboys this weekend, and a little nervous about it with the way the 49ers have shaken down. We could have a whole nother training on that, but I don't think we need it. But I give these pictures to demonstrate that I'm human, and I purposefully omit the pictures for Kevin to show that he really, no.
Right.
Kevin, tell us a little bit about
So I'm
yourself.
going to narrate what my slide would look like.
Sorry for the folks back home. We're having technical difficulties. Why don't you describe to them what
I
they're
am
seeing?
not married. I do not have children. Well, I'm not married, but that doesn't mean that yeah. And then I do not have children. I have no plans to have children. I think that if my slide would be full of my travels, yes, like Christy said, there's an island called Mykonos, which is a Greek island in the Aegean Sea that I go every year, except for COVID. I am going on a cruise in 2 weeks. I love Tel Aviv. I am really involved in the Jewish community. I'm on the executive board or regional board for ADL, and I'm also on the national commission now for ADL. ADL is the Anti-Defamation League. Mostly an organization formed to stop the defamation of Jews, but it is much more expansive and much more broad. So that's a lot of where my time goes, and so that would probably be in my slides. And I love to shop, so maybe a few labels on that thing.
And as you heard, Kevin's a partner with his firm,
Oh, right,
which
yeah.
takes up a ton of time for him. Like I said, I'm an owner in my firm. It's easy to take an attorney, let's say on the other side, and just break them down to just their simplest form. And to and when you do that, or when you do that with a claimant, right, or when you do that with a coworker, it makes it that razor's edge that much thinner to be able to make the proper ethical decisions. Interestingly, right, when you just put on the hat of being, the hardcore adjuster that thinks that you're out there to deny claims and to save as much money as you can on the individual claims, then you miss the point of what you're really supposed to be doing. We'll show this little video. I don't know if it should work here with this little video. No, I'm scared. I don't know if that video will work.
No, listen. Can we just mute it until the video starts and then play the video?
Well, I'm about to try that, and
Okay.
we'll see how that goes.
Okay, cool.
Everybody hang on, because we may just enter into like a
Right.
Disney time loop here.
Disney time reality. Yeah.
Can you hear? This is the time warp. See if they can hear it back home. Yeah. It's all part of the show.
It's all part of the show.
Thank you, sir.
It's all part of the show.
You wanna stop it?
You want to stop it?
Sounds like my mom. Do you want to stop it right now? Why don't we just
I
stop
probably
it?
do say that to my 5 children, yeah.
Why don't we just stop it right there? No, so I mean, obviously, I've shown the video before. Every year, I think about changing it up to a new video. I think it's one of the best expressions of the way that we're viewed, by the claimants bar, by employees in general, right? You have developed a rapport with you, Sandy, with your employees that they feel like you're someone that they can come to, which is great, right? Which is where it all should be, and you should be giving them the right direction, while maintaining your ethical standards and your responsibilities. But more often, we're looked at as the little pencil neck, right? We like to view ourselves as Mr. Incredible. That's the one that's not like, but the way that we're viewed, the way that claimants come into this system is scared. They feel like the deck is stacked against them. Some of the marketing that's out there fosters that type of impression. But these individuals have just been involved in an injury. If you're a third-party administrator, if you're a third party to the claim, right? So an insurer, right? Then the employer probably feels the same way, right? Because you're their insurer, and what do we see all the advertisements say, right? Like your insurer's going to try to weasel out of paying out on claims that you've already paid for, right? And so at HMC we developed like the iconography of an anchor for our logo, because we recognize that coming into this type of a system, most of the parties that are involved in it are in an unknown. Their world has been shaken up, right? They're and we like to refer to it like it's a stormy sea, right? Nobody really goes into business other than us, thinking that hey, I'm excited that and expecting that one of my workers is going to be injured, right? If you start up a retail outlet, you probably just check the box to get work comp insurance, right? Because you're filing for all of your different licenses and insurances, and you just probably check that box, and it probably doesn't cross your mind at all that one of these individuals is likely to be injured within the first year, right? And what are you going to do with it? And if you're a worker at a retail outlet, it's probably not crossing your mind at all that when you step up on that step stool that it's gonna give out and that you're gonna be injured, right? And so we come into this, it's easy for us to look like the bad guy. It's difficult for us to actually play a proper role in the work comp scheme. I'm gonna skip through this one. We've seen this video as well, but if you want to just sort of give your impression, Kevin.
Well,
about it.
no, and I'm not
feel
going to really dispute what he's saying. It's just on my end is that when you are representing someone, I will say generally most of them have never been injured on the job before. I mean, certainly I have lots of files to pull from where that's not the case. But usually it's their first time, okay? You have to manage all of this, okay? So if they're coming and they don't trust that, they don't like their employer, they think that the insurer is there just to screw them over, they're nervous, there's the unknowns, they're injured, can they work, what's gonna go on? That's my job and my team's job to manage all of that and to manage all of that stress. And that's why they hired us. So, that's just a layer that, there's a lot of things that people don't consider when you are representing people. And then it's, sometimes you really have to kind of reel people in and be like, no, this is normal. Oh, they're not or they come to us because they haven't gotten a response or something along those lines. But you just have to manage all of that. And I will say that probably the best, I give good advice all the time. No, I will say a good piece of advice that not all of my clients, but that I have to give at times is that if you really invest energy on thinking, that everyone is out to get you, maybe even including me, including the court, including all of that, you're just adding to the enormous amount of stress, okay? Because I mean, just think of this injured worker, okay? They're making 66, say that their employer doesn't have light duty work, okay? They're making 66 2/3% of their wages. How many of you can live off of that, okay? They have a family, they have kids, they still have to pay for health care, they still have to put food on the table, they still have to pay the outrageous price for gas with inflation and all that type of stuff. They still have to do all of that, okay? So when you're talking about a stress level, okay, we have to manage that too, okay? So it really is quite, and you're not suing anybody. It's not a lawsuit, you're managing the claim. So really guiding the injured worker through all of that, at least in my practice. People skills, okay, if you don't have people skills, you will not be a good plaintiff's attorney for workers' compensation, okay? You just will not. You do need to genuinely have those people skills. And the people that work for me, including myself, that are successful in litigating and handling claims for injured workers, we've got the people skills, because that's the foundation.
Well, yeah, I mean, they come in thinking that their employer injured them, right? I mean, that's the first hurdle for Kevin to overcome with his clients. They come in and they're like, my employer injured me. I'm not going to be able to work. They're going to fire me, right? Like that's the norm, right? And I found when I worked on the other side for a very brief stint, I found that that my job was easiest if on that first interaction I could teach them that, hey, and this is something that you can help them with a little bit, right? And I'll give you some sort of like key terminology that you can use, but to teach them, this isn't about, who hurt who. We have a process to go through here, and there's certain rights and benefits that I, as the adjuster, that you as the employer are going to be offering, and there's some that they probably won't get, and if they want to get an attorney, then they're free to do that, but your job is to adjust the claim based upon the law, right? If you can foster an environment of safety, right? And we usually refer to that as like an OSHA type standard, but if you can foster an environment where that they feel safe in dealing with you, then you can work through most of these problems, right? Without having a big fight, right? And that will be appreciated by Kevin, right? If Kevin stays out of litigation, right, and only has to guide back and forth a little bit, that's Kevin's best case, right? And his guidance, helps to keep the injured worker, manageable, right? Which not all of them are, but then all of a sudden you're having your best day and Kevin's having his best day, right? The easiest case to work on as an adjuster, I should say, the easiest case that I found my adjusters work on are the ones where, one, it's a proper claim, right? And two, all the benefits get divvied out according to statute, right? And three, the claim gets closed properly. And that doesn't always mean closed without benefits, right? But those are the easiest cases, and those are the ones that you feel the best about, right? And those are the ones where that reopening gets requested 5 years later, and you have no problem saying, oh, absolutely, right? This person putting the note in. This person was good to deal with, right? Claim closed out, seemed as though there was no interruption. Oftentimes, we start to view ourselves, because of our past experiences, as gatekeepers or as soldiers for our administrator, right? Whose purpose is to defeat the other side.
And if I can add to that, that's exactly right. Kevin made a comment about communication and all of that. As an adjuster, if you have a bad attitude, think about retiring, because that causes problems. If you pick up the phone, or worse, you don't ever pick up the phone because you have an attitude, that causes problems. It is shocking in the 300 years that I've done this, how many times I get involved in problems and it starts with the adjuster. The adjuster is an ass, period, is an ass. And when people give me a hard time because I give my cell phone number out, and I assure you the injured workers use it.
I assure you.
I assure you they use it. When they call me though, they don't call me and go, hey, they don't. They call me because they've tried, and they tell me, I tried so-and-so on this date, this date, this date, this date, this date, this time, this time, this time, this time. And they've never had a call back. They weren't called back. When they called back, the person wasn't asked to them. They had issues. I've never heard anything they don't understand. When you get a claim, in the very beginning of the claim, the requirement as an administrator is that you call that injured worker. You need to. Because just like these gentlemen have said, they're in a spot. And you being that non-responsive, lack of personality, attitude carrying individual is only gonna make your job a lot worse. And Kevin, a lot richer. Because it's not necessary. When, you know, and I'm just gonna say this, the attorneys know when you come in, you go, oh, my adjuster's Ann. They go, okay, cool. They know Ann. They know how Ann's gonna do it. So don't think that because you sit in your house in your pajamas, they don't know you. Because they do. They know you. And this is a people skill absolute business. And if you are not talking to your injured workers continuously and on the time, you're not doing your job. You're straight up not doing your job. All of us can push papers, that's not a big deal. It's the people skills that Kevin said that are critical to what you do. And if you don't mess around with that injured worker and you give them that information at the beginning and you help them get them all the way through and all the way through, it's a smooth sail. It's this bedtime story that Sean just told us. But if it's not because you never answered the phone, you never talked to him, you've never had the opportunity, and when you did talk to him, you talked about his wife that was screeching in the background, it's not going anywhere. It's not going anywhere. So it doesn't benefit you to do that. If you need to take classes on personality, do it.
I actually talked to one of your employees, and I don't.
One of
mean
my
to-
employees?
I did.
Oh.
I don't mean to like throw out Corvell, but
Oh,
but they did say that on every single claim denial that they do at
Yeah.
Corvell, they call the patient to
it's
tell
required.
them that you're denied, and here is
I'm a
why.
nutcase.
And so
It's
that
true.
person, yeah, so she told me basically that it helps so many times for them to explain it to the patient, and then they're like, okay, I understand. Or they're like, I don't believe that, and I wanna, but more often than not, they do just, okay, thank you, and then that's it. But
Because
not
theoretically,
everybody calls, they just deny, they get the letter in the mail, and then everybody goes, oh my God, and then go get an attorney, right? That's,
which is why we have 25 billion cases backloaded.
So I was going to ask.
Well,
So
that's the hearings division.
Yeah.
That's all there. Yeah.
it's all of it. But how many of you have been working with claims or in the industry for more than 10 years?
Of course, we can't see anybody online.
And
but,
and how many of you are less busy today than you were 10 years ago on a
Less?
desk?
All right, sure.
whatever.
Sandy does not count. She
Yeah,
just
Sandy does not
she
count.
just told us she's an employer now. So
Yeah, she does not count.
no, I mean
That's now
there are more claims. There are more claims today than there ever have been. Our economy in Nevada, and especially in Las Vegas, actually Las Vegas and up in Washoe County, they're exploding, right?
Everybody's saying way more busy.
The national
This is no one, yes and
expectancy
yes.
of an adjuster now is 140 to 150 claims, nationally.
Yeah.
That's what they say with
Right.
the technology we have and everything else, that you as an adjuster should be able to handle 140 claims.
Well-
I say bullshit,
And it's
So there's
so how does the technology?
too much.
This is a question, and maybe I'll add a new slide to it for the next time I do this. But how does technology help you with your ethical responsibilities?
or hurt you.
How
Huge. Huge.
how can it help you? Not that much. But let me see. What's your suggestion? It's
Well,
good.
I come from the case management, but
It's Cody.
I have
Yeah.
this discussion all the time with physicians, I have it with employers, I have it
Right.
with patients. Documentation is everything.
Right.
If it isn't documented, it didn't
Didn't
happen.
happen. Right.
And so.
Documentation's a lot easier now. You're absolutely right. Covering your bases, way easier, right?
If you're smart enough to just do it.
Right.
You have to do the documentation. I mean, if I have an injured worker that I was working with, and then they got an attorney, and that attorney doesn't allow case management. I just had it the other day, and the patient called me, and I said, right off the bat, just so you know, I don't have clearance to speak with you. I'll of course answer if you need something. Tell me, maybe I can handle it if it's just, doing something. And then I have to immediately email the attorney and go, hey, this person called me. I did inform them again that I don't have
Right.
clearance to speak with them. Here's what they wanted, here's what I did.
Right.
Like, if you don't document it, then that attorney doesn't know
Right.
that they can trust me. The patient doesn't know that they can
an email to Kevin
Yeah.
saying, hey, just so you know, today,
An email.
Kevin loves emails, but
I do.
but just kidding. For the record,
Kevin
again,
has case managers
so-
in his office that
right.
can email.
But an email to Kevin's office, right? That says, your client X tried to speak to me today. I told him that you couldn't, or that I couldn't, right? That goes into the file, and when Kevin goes and pulls that file and sees, a couple days before a hearing, and sees, hey, there's a log of all the times that this client has tried to get information or tried to speak with an adjuster where I've told them not to, and the adjuster has commented us, immediately Kevin is on your side, right? He's also on his client's side. There always doesn't have to be this big side, but he's on your side of who am I dealing with? You're no longer the enemy. Now, there's still things that Kevin and I are going to argue about in the law as to whether or not benefits get pulled, but Kevin is immediately on the side of, this is not an adjuster who's trying to fill in the blank
At
for
least he
me.
knows that there's some sort of,
But that's always obvious. I will tell
Correct.
you, the volume that I do, behind GGRM, Ship and Stone is the second largest in the state. So the volume that I do, I can pull from a lot of different types of cases. Now, I'm going to go back on something about the permission to contact client. That's going to be different from attorney to attorney. I welcome the contact because it's easier for everybody. It's easier to facilitate, and quite frankly, I'd rather have a nurse making medical decisions than an adjuster. Okay.
Amen.
Now,
or at
I.
least intervene.
I have, there are a couple that I've had to read the Riot Act before. I mean, like, okay, you are a nurse, meaning you have a license. Okay, your obligation is to the patient. Okay, so, and certainly, just like, any doctors or lawyers or whatever, you can file a complaint. I mean, I've never had to do that. But I just will say that it is helpful to have the nurse case manager. What I do, here's what this is just my style. I give the option, like, I allow contact, okay, unless you give me a reason not to, okay? But I leave it up to my client of whether or not they want you in the room when you go to the doctor's office if you go. And the reason why I do that is because I have found, okay, in this particular instance, again, I speak only for myself. So if you do kind of some hard-ass line of yes, no, yeah, this is what you do, you just end up causing more work for everybody, and it drags the claim out maybe even further, and you don't know the comfort level of the injured worker. Okay, some people of my clients, they want the nurse case manager in there because they want to know what's being said. Okay, they are not comfortable with that nurse case manager. On the flip side, they don't want them in there. Okay, but yet they're uncomfortable that they talk to the doctor without them afterwards. That's going to be from person to person, so I literally leave it up to them. But that goes into an ethical obligation. Yes, I have to grant permission. Okay, I decide that this is how I'm going to run my practice, and this is how I'm going to let people communicate. Adjusters, that's different. Okay, but nurse case managers, that's always kind of been. It wasn't that way in the beginning. I was a hardline no when I told everybody no when I first started. Everything was a no. Okay, but then I realized that was not the best approach. Okay, and so and I, all other colleagues still take that stance. They don't want any communication. Others do. So
We do have a question online. Is Suhair, can you unmute and ask? I know you had your hand up. I don't know if you did that on purpose.
Nervous about unmuting.
Huh?
It's going to lead us into the time warp.
In the type warp. You do not have to unmute. Suhair did.
And while they're pulling up Sue here.
Okay, Nancy Burley has a question for Kevin. Go ahead, Nancy.
They can write it out because unmuting is not working.
Yeah.
Lori Mole says, I think it depends on the company. If you work for a good TPA, then it goes very well.
Well, and I'm going to add to a couple of those comments.
Go ahead. Nancy, type in your question in the chat
I
line.
find that depending on my employer, different TPAs attract different types of employers. Different employers have different attitudes. So as an adjuster, if you're dealing with an employer and you know he's running a sweatshop, your attitude is one. If you're dealing with an employer like the Water District who caters to everything, then you're dealing with that. So as an adjuster, you also need to know the culture that employee is coming from.
As an employer who took over for a person who was ruthless as the employer in my last job, as the employer, you need to understand the law.
Yep.
You need to keep up on the law,
Yep.
and you the adjuster. And any TPA that allows an employer to ask them to break the law, get rid of that employer. I don't care how much money they're paying you.
That's
You
exactly
cannot, as an employer, ask an adjuster to break the law. And my first 60 days, and I'm gonna call it, at Clark County, every time the adjusters came to me, I'm like, well, that's illegal. Well, that's illegal. And I had a parade of union reps outside my door. And once I educated
Everybody.
union reps and the different departments, it ran very smoothly.
Right.
But you cannot, as an employer, ask your TPA to break the law.
Nor can the injured worker ask me to break the
Correct.
law.
Yes.
I mean, so this
Well, they can
has
ask.
broad, yeah, they can ask, but they're not gonna get anywhere.
Right.
And nor can they, like, we'll get into this slide later about candor to each other and candor to the court. All of you in the audience would probably die if the rules of ethics with criminal defense are so different. But even like with this, I can't, there's ethical obligations I have confidentiality with my client, but there's a fine line that I can't let them, like if I know they're lying, I can't have them take the witness stand and lie and not tell the court that. And nor can they use my services to perpetrate a fraud. So those Dateline NBC, I call them videos,
We got
okay,
one
that
here,
are
but we
far,
won't be
well, yeah, we
watching
do.
it, yeah.
They can't use my services to perpetrate a fraud. But again, that's up to me. There's no hard fast, you don't make that decision. I make that decision as a lawyer, so.
So there is a question online and it asks, why do attorneys' offices appeal everything and assistants don't answer the phone to discuss?
Oh, should I open up your canned answer to that?
I'm
No, just
sorry.
kidding. We do have a canned answer to that.
Yeah.
So,
We do know that answer.
Well, so I can only speak for, again, this is as I led into this conversation and that I'm here on my own. I'm a partner at Shook and Stone. I talk about what I do and practices I do, okay? I do not appeal every letter. I appeal letters that preserve my client's rights. This is an example of we don't do the same job, okay? I'm appealing, I'd be happy to sit down with you of why I appeal certain things, okay? Let me give you an example, all right? And this comes up every time and I'd be happy to share with it. The claim acceptance, I appeal it. Why? To preserve my client's rights, okay? Because if I don't, all right, what's going to happen, what will happen 100% of the time, all right, is that you will if we go to court, okay, if it's not appealed, and the scope changes for whatever reason, it's gonna come back on me. Your lawyer, no matter who they are gonna come and blame me personally that I didn't appeal that letter, and then my client gets wind of that. I mean, so it's not as
So I have a
simplistic
question.
as you think, okay? So, because guess what? All fusions, do they start as a fusion? No, they start as a lumbar strain, okay? So if I don't appeal that, now, yes, if you buy it, you own it, and there's all these things, and you amend, some of companies amend the scope. If I could have a wish list, if you amend it, include all the body parts, and I can dismiss the first one. Again, I only speak for myself. But so there's that. Now, do my people answer the phone? I don't know. I mean, certainly, I can't attest to that. I don't have, that I'm aware of, any communication problems.
that's as good.
Sir, I will tell you that I have 99 hearings next week, and I want to say 65% of them are de facto, meaning I didn't get a response from at all. So the communication definitely is an issue. Certainly, if you have a communication problem with my office specifically, this is the first I'm hearing of this.
Yeah, I think that
But I think it's good that you talk about this, right?
Yeah.
Why do you
Yeah,
appeal
absolutely.
your
That's why we do it
acceptance
like
letters,
this, right.
right? So now, every adjuster on this call, 115 of them are gonna say, okay, I know Kevin's office is gonna appeal this acceptance letter because now I know if this sprain turns into a fusion, this is why he did it, because otherwise we wouldn't be able to add it later.
well, and that's leading to.
And I
As
love
Sandy
that.
just pointed out, there's a statute that says if the medical evidence expands the scope, you have to.
Well, scope's always
So-
at issue under AMR Dickinson until the claim is closed,
Yeah,
right?
but
And
if you're
as long as there's ongoing medical treatment, scope should be at issue. But what Kevin's talking about here is that, and he says 100% of the time, it's a little bit colloquial, I think, because he says 100% of the time that he doesn't appeal scope. He sure is going to get bit in the behind because there's enough attorneys out there that argue it a certain way.
Right.
That he can't leave his client out in the wind.
Right.
And it's the same is true of all what we're talking about earlier. Kevin says when he was first out, or when he was first in work comp out here, he would tell his clients, don't talk to the adjusters. I want to handle everything. right? And then he realized over time, then he realized over time that that just wasn't functionally beneficial to the client. It wasn't workable with his practice, right? And learned all those things. But for every Kevin that's withstood the test of time in work comp, right? There's a couple more that are just coming in, right? And this is sort of what we're getting to. I'll skip past this real quick.
Well, and just to add on
These
that,
are all
okay,
people, and if you think that you're, sorry, I'll just
That's right.
finish. If you think that you're in a business other than the client customer services business, right, and you're a forward-facing individual for your company, then you're just wrong. If you think that you're in the technology industry or the data entry industry, right, like, or that there's just some mechanical function that you have, like you're on an assembly line. My job is just to crank through these work comp claims on the documents and then pop out a closed file at the end, then you're just wrong. You're cutting out probably 2/3 of your job, and you're not upholding your ethical responsibilities that the state has put on you.
So I was just going to say is that this is a topic, this is where I talk about how there's legal ethics, what have you. Well, Sean and I are the only attorneys, I think, in here, okay, and I don't know how many are on Zoom or Teams, whatever we're on. But this is, again, this is what I'm talking about. This has solidly mostly to do with ethics on my end, okay? That a client comes to me, it is my job to protect their rights, okay? So the decisions I make as an attorney of what I believe are ethical, number one, aren't here for debate, okay? Number two, will vary from attorney to attorney. And number three, I'm not wrong.
Ever.
I'm not. I
Know
am
about
not
this.
doing anything. I go down to ethical. I would much rather, and what I do with claim acceptance, again, now I don't speak for other attorneys, but just sharing that one example, okay? It's just one, all right? I have then protected my client's rights. I have to provide competent and diligent representation to my client. We're a large firm. So I cover those bases by doing all of that. And I'm not expecting necessarily adjusters to agree or understand or what have you, but it's really irrelevant because it's ethical. It's my ethical responsibility to my own client.
So online,
You don't have to read them all.
why with de facto denials do you not call the adjuster?
why do I need to? Why aren't you doing your job and doing it in 30 days?
Well,
Yeah.
So if there isn't a response for your request, why not call them? Somebody else said,
Well,
if you respond to the de facto request, you can get the hearing dismissed.
Well, so now let me follow up on that, and let me tell you what I did that didn't work, okay? Because this is that what I did is de facto is starting to be such a problem, especially during the pandemic,
Huge,
okay?
right.
For various reasons,
Yeah.
okay? And I don't want to get into that discussion. Certainly, it's a Achilles heel for me, okay? But is that there is a law, folks. You must respond. You shall respond in 30 days, okay? So I don't need to call you and say, hey,
Can you please?
can you get me that response? Okay? I don't need to do that, all right? But the reality is that I instituted, okay, and I'm going to tell you, it didn't work. I did it mostly for the hearings division, okay? Because I was expecting when I get in there, okay, they've made some headway down there, okay? But I was for a while, and you may know this, okay? It was taking 4 months to get to a hearing, okay, in Las Vegas, all right? So if that was a de facto letter where I've requested an MRI and you haven't responded and I'm getting in there 4 months later, we're talking 5 months, okay? And I'm representing that person's interests, okay? So if it's 5 months, I pled with the hearings division to put language in the decision and orders to be like, look, it's been 107, or whatever many days, it's been 110 days and you haven't responded. Like, an employer will see that and be like, what are you guys doing? But there's only one HO that would do it, okay? So there wasn't a lot of accountability. So guess what? I still have, 60% of these de factos. Now, yes, we do certainly, dismiss them as there is a response, but I love where, again, the volume I do, okay, we have deadlines and cutoffs of when we address things and when we deal with all of that, but I love the 12th hour, or the 11th hour, the 11th hour phone call, the hearing tomorrow, here's my response, and my team and I are just supposed to jump, okay, where we have already gone through a calendar meeting, we've already made the packet, we've already done that. I mean, when we don't go to one hearing, okay, 5 people in my office, including an attorney, touch it. 5, okay, because it's that much labor intensive. So we try, but also remember we have a huge volume, and so, it's not perfect.
Well, and like you said, if past experience had been that every time that you called an adjuster about a de facto denial, the adjuster, all of them, picked up the phone first, right? Because they have all the time in the world to pick up the phone when they have all these de factos on their desk, which nobody's arguing over the volume, right? But they picked up the phone and they immediately issued a response to it. Then Kevin's office would probably respond to that by making the phone call first, because he just told you it takes 5 people, 5 whatever, portions of an hour of labor, right, cost to get to a hearing, right? They'd probably rather do that. But the truth is that in the environment that we're in today, we're all worked harder, we're all expected to do more with less time, right? We're all, because everybody's shortened these times because COVID, we're all expected to perform at a level of accuracy that's higher, because everybody wants their Amazon package today. Believe me, I've searched like 30 times in the past year over why that Amazon Prime Now went away, and I have to wait 2 days for my packages again. It's just not right, right? And if I don't get the right package, then I get to file a grievance, and half the time they let me keep what I got, and they just send the other one to me, right? Like we all have these expectations because of technology, because that we were allowed to work from home, and technology's created an environment for that, right? But our expectations are too high for people outside of ourselves, and the truth is that the reason that he appeals de factos all the time is that the statute says that if it's all but one case, if there's no response, then it's denied. And the expectation that Kevin would not appeal a denial of a request on behalf of a claimant is sort of absurd.
Very.
Right?
It's ethical.
And
right?
it would breach his ethical duties, right?
Here's the other thing is I forgot to tell you as I went on the soapbox about what I did, but it didn't work. But I really did it mostly for the hearing officers, but also for the adjusters. So this question about why don't you call us? My claims managers, I told them, I said, all right, when we get these de facto notices, I said, reach out twice, try 2 emails, okay, to someone saying, hey, can we get a response to this? Can we get a response to this? Can we get a response to this? So were we 100%? Probably not. But I literally instituted that policy to try to do that, and it didn't really move the needle in regards to the de facto. Also, some of the claims managers are on here. If it became a real systemic problem, I have reached out to them to say, look, and use the systemic problems with either de facto or service of process. I will tell you is. Again, I do this, folks. I know my colleagues don't, okay? So I do it because I believe it's beneficial, and I believe that it's beneficial to my practice, and I also believe that I use the right approach, okay? So people on here, I don't know if Lorraine is on here with Army, Rosemary, there's a lot of people in here that I've reached out. I hate to call people just because there's a problem, but when I have been like, look, here's this issue, can we fix it?
Yeah.
I have been so thrilled at the response I've received, and again, that's me. Okay, I literally am willing to do anything I possibly can to move the needle onto the stuff, no matter who's right or wrong, but there are third-party administrators and insurers that I just don't have this problem though. Like I mentioned, Army. I don't think I've been to a de facto hearing with Army for years. Okay, they just don't happen. Corvell, it doesn't happen. Cedric, not really much anymore. And so. There are different TPAs that at Hartford, I don't really did things. So there are insurers out there, right, that I just don't. So we've tried, okay, and I understand staffing, I understand all of that, but I wanted to add that we tried it. Now I stopped it because there was no benefit and it wasn't moving the needle. So why would I then invest more staffing of people to do something like that?
Online, wait, can I just read these real quick?
Yeah.
Okay. So online, plaintiff attorney's office, respectfully, I would assume it's being de facto appealed after multiple attempts have been made with no response. No, that's not what I'm saying. With us, 9 to 10, you have the paperwork. I don't know what that means, Nancy. Why? It is possible that the person didn't get the request. Yes. If we respond, we can request you dismiss it. Communication is key. It is possible you did not receive it, but when you did get the notice of hearing, there is your notice, as it includes a copy of the letter. Right. We have 73 days to appeal a determination. If we don't, then we're screwed. Okay, sorry. You have 33 days and you don't respond. What's the repercussions? Nothing other than us having to file a de facto appeal to possibly get a response. Sorry.
Agreed.
Well, listen, the truth is that everyone, if you can give value to the fact that everyone has a hard job, right? Everyone's has been through the past couple of years in totally uncertain times. Everyone's been reinventing this wheel that we all sort of relied on that wasn't really working going into the pandemic because we were trying to keep a hold of a vestige of the past. But if you can understand the arena that you're in, if you can give, like I said, a little bit of grace to those who are entering it new because they don't understand on both sides, right? Then everything becomes a whole lot easier and more stomachable, right? I see a bazillion de factos. I get calls the night before without file contents to go into de facto denial hearings. They're all over the calendar. The courts have contacted us about it and talked to us, the bar, all together about it and individually about it. And it's a problem right now, but we also, everybody in those rooms understands, one, that claims are through the roof. Two, it's really difficult to get the communication going for one reason or another as we build back from COVID. And three, when you're in those rooms, there's no harm, no foul. When we go into a morning calendar and Kevin's got 10 de facto denial hearings in a row on different claims, he doesn't go into it yelling at Sean, right? I don't go into it yelling at Kevin because half of them are going to be dismissed because somebody took action on them, right? You go into it recognizing, hey, we're in a weird time right now. The rebuilding, the building up of an infrastructure is going to respond to the market's concerns. And that's where we're at. And when you start to give that kind of grace and when you start to look in that kind of way, and believe me, and Kevin will attest to this, it's not like I'm a sheep here, right? I mean, I'm a pit bull, right? I mean, some people say Chihuahua. I'm a little bit smaller in stature, but I bark. But I bark and I bite when we go into hearings together. And I'm one of the more heavy hitting. Yeah, because there's enough issues, right? Besides all the things that are mistakes that happen through the process, and besides all the things that are, hey, I got ticked off at Kevin, so I slapped him with a denial on something, right? It's probably not warranted. We'll talk about that later. But despite all those things, there are enough issues that we get to hotly litigate together, and where we get to fight about them, that it doesn't make any sense to get our feelings hurt about things that are just growing pains, by and large. And we'll respond to it, and the industry will grow, and it'll change. And things will get better.
And not all de factos are the same. I want to say that too. Is that we guys standing or sitting up here painting with kind of a broad brush. Not all of them are the same. Like, we get it. If you say that you're waiting on wages from the employer, I believe you. I certainly, you still are obligated to provide it, but things like that. I've tried to adjust. Again, this is just me, okay? I've tried to do my part, okay, in trying to, like he's talking about the functionality of the hearings division, okay? So for example, bill pays, I've used a different approach where we don't want all these remands out there either, is like, if we get to that, if there's a de facto, for example, of a bill payment, okay, because my client has provided me a bill that we believe should be paid under the claim. If there is no dispute that they're going to pay that bill, I just have the hearing officer, and your lawyer will say yes or no. Right. I will just have the hearing officer reflect that in the decision, and then just say they're going to pay it. Great. Well, that's then the law of the land, okay, and we don't all have to deal with anything else, okay. So these are just little things that I'm trying to do because, again, I have a huge amount of cases. So I really believe that I can single-handedly make an impact, on my side as well.
Wait, real
Miss
quick.
Sandy,
Real quick, before we do that, can I read these real quick online? So we have this is an adjuster. We have a huge volume of work, and it does not help when these attorneys demand getting served via mail, fax, and whatever else they request, just to make things harder on us adjusters and add more unnecessarily work. Unethical. 100% agreed. The demands on the adjuster have increased exponentially, and this is why some of us are leaving the industry, unfortunately.
We'll miss you.
Where are they going? I'm very interested. I know half of them went to,
So I'm sorry, I must.
Go ahead, Sandy was going to say something real quick.
Can we talk about reasonable cost? If I'm hiring an attorney that goes to a hearing, that goes to an appeal, that goes to a settlement conference, that goes to a date specific and blah, 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 and has to respond to all of the resetting over an MRI? Are you kidding me? And then we're gonna get an IME to see if that person needs an MRI? Get the MRI.
Well, this is,
You're gonna be hard, that's gonna be a hard sell to
and,
me as an
and this is
employer.
sort of the point, right?
Right.
This is the point. When you start to recognize that you're working with real people, and that this isn't like the rules don't apply because now I'm at work, right? And I have my own set of, whatever you want to call it, like prison ethics or something like that, that I put on when I'm an adjuster
those?
or when I'm an attorney. You can't do that, right? You are required to be a good person and to follow the ethical rules and to follow the law, right? And when you start to get into that mode, some of that comes with time. Don't get me wrong. This is getting into this system and being brand new is difficult for everybody, right? And so some of that comes with time, being able to function like a real person and also do your job. And the volume is high. Don't get me wrong. But you start to make decisions that make so much more sense and abide by the entire principle of the Industrial Insurance Act, which is to ensure the quick and efficient payment of compensation to employees who are injured or disabled at a reasonable cost to the employers, right? Your responsibility there, as somebody who participates in this Industrial Insurance Act, is to meet all of those requirements for you. Otherwise, it won't work, right? This is the underpinning for the act, right? So you should ask yourself, rattle it off real quick in your head, every time you make a determination, every time you get up in the morning and go to work, you should ask yourself if you're operating in reality. Because if you aren't following these premises, right, at least to the best of your ability, then you're operating in the wrong world. You're out going into the basketball game with a baseball bat, right? I mean, it doesn't make any sense, right? You're operating in the wrong arena. And if Kevin does that, right, if he allows his client to come in and be like, I want to sue them for what that they've done. And Kevin can go, let's file a lawsuit. But he's operating in the wrong arena, right? He's not going about it in this same way. And we're all saying the same thing, right? If you were to really look at these requests for an MRI as just requests for an MRI, calculate out the expense of going to hearing, because you know that Kevin, if you don't answer it, Kevin's going to take it to hearing. I'm obviously harping on Kevin, but Kevin's going to take it to hearing if you don't answer. If you do answer and you deny it, Kevin's going to take it to hearing, right?
Or ask for an IME.
Right.
How
All of a
much for
sudden,
IME?
you issue a determination. Right.
1,800?
I
you-
just- I could give-
You issue a
give
determination.
$100 for an MRI.
Right, and I hardly ever see him anymore, but you issue a determination that for diagnostic purposes and without accepting any additional conditions, we are approving your MRI on a rule-out basis, right? And then Kevin doesn't do anything with that. He can't. Otherwise, he looks like an idiot, and the hearing officers yell at him, and if he takes it up, then the appeals officers really yell at him, right? So he can't really do anything about that. Some will, and they will be wrong, and then you just have to go, well, because there's some bad actors in the system, we have to expend money even when we're trying to do the right thing. But it will become so few and far between that we'll start to build up an infrastructure that will be able to facilitate, working through all this together in a reasonable way. And you'll be able to
And when was the
adhere
last
to your
time you
ethical
saw
tenets.
an appeals officer not say, I see a medical question?
Yeah, of course.
Get an MRI.
So I want
Right.
the one comment about, this is practice specific, but May 31st of 2021 is when the law changed in regards to service of process. This is an area that I think that adjusters in the insurance world knows the least about and values the least. Because service of process is, there are rules of civil procedure. It is a big deal, okay? You must serve people if you are going to, not only in work comp, but if you're gonna file anything, you must serve them. And there's only certain ways that people can be served, okay? Email's not one of them, okay? But, so, I'm talking about generally in other lawsuits. But so what happened in regards to why do you get requests that you want all of these things? I make one request. Again, can't speak for anybody else, but in big capital letters of paragraph 1, okay, is a fax line that I literally set up through Shook and Stone just specifically for service of process. Why? Because number one, it's easier to manage, okay? And another reason is because during the pandemic, before the law changed, people were always trying to fax and doing things, and I was like, okay, the law, you needed to do it via US mail. So again, my ethical obligation
No, you need to mail it. I'm not going to accept fax as a service of process. Doesn't mean we won't, that we're just going to throw the piece of paper away. But there's only it's only an issue if it's an issue. Okay, so if you are not serving someone properly and it ends up being an issue, then you're not following the law. But I remember when it was only U.S. mail, I only accepted U.S. mail, okay? Because guess what? It's my responsibility to manage the inflow of documents of all of the cases and all the clients that I have, not yours, okay? And so, and other people do it differently. I know that some colleagues use the fax when the law changed, some don't, okay? But so I set up this fax. People were pissed I wouldn't accept fax before. Well, now that I have a designated fax line, people aren't sending them to the fax. They're using a completely different Shook and Stone fax. Don't know where they're getting that number, but they're using that. So I've had to man all these different ways of sending in documents, never mind you emailing a document to me or my staff or whatever. You're going to get the piped response saying we don't accept service of process like this. Why? Because it's my ass, folks. And this document, I don't know if you sent it to my client. I don't know. Do I need to appeal it to preserve rights? If I don't, then great. But I have a specific process in place where I screen determination letters and determine what needs to go where. And so that's all set up. And so if you circumvent that process, and that becomes an ethical dilemma for me, because I could screw up my own clients' cases, okay? But I just find in this situation, I'm damned if I do, damned if I don't, because I've got it set up for fax. People either don't use it, or sometimes people refuse to use it. You go to court and say, I'm not doing it. Best of luck with that. Anyway, I'm just, that's...
And I think that I can add to that and the comments there. If you are burnt in our business, please go on. Please move on. Because if you are not happy in your job, you're projecting that. And that's bad. That's like the old school teacher that smacks people's hands still. So that being said, as an industry, as an administrative, I'm talking to the work comp adjusters and stuff like that, we as a group need to get together and figure out how to evolve into this world. Because in this world, it is very data-driven, it's very, you do much less case management, you do a lot more data mining and stuff like that. We as an industry have to evolve. These guys, the legal side of it, they are evolving. That's why they got this fax, that's why they're doing all those things. For us, we're not. So I agree with you guys that it is a lot. When you have to hit all those buttons and do all that stuff and all of that, and we can't do this and that and the other thing, I agree. We as an industry need to figure that out. But you have to also understand that you personally, don't nobody care. Don't nobody care. It is a process that we do. We are medical case managers and administrators to what we do. You can't make your own rules, and you can't argue all the time. Yep. You have to, exactly what it said up there a minute ago, you have to deliver benefits. That's our job. It is to give them benefits. So when someone calls you and says, I need to get paid, figure out how to pay them, not how to not pay them. Right. That's the kind of thing that we have to change as an industry. We have to quit with the mind. And I'm telling you, I'm old. So I understand where we were and where we are. And I don't want to be an adjuster. I don't. Yeah. There's a job right now open that it's got this big. It's like trillions of dollars. I wouldn't take it. I don't care. I wouldn't take it. And that's because it's hard to be an adjuster. Let's take a potty break.
Yep.
See you guys back in 10 minutes.
10:35.
10:35.
10:35. We'll see you back. Yeah. You guys want raffle tickets in here? You could buy some. Catherine's got the raffle tickets up front. We got tons of gifts back there, including Coach Purse, Kate State. Oh, it's Coach? You brought one too? Oh, is there another Coach? Or another? Oh,
So will they get?
That's a big dollar.
Yeah.
I don't think we I haven't, no. You guys, one of the we're gonna see each other's names sooner or later. Sure.
Right.
So I don't know how so I can make it. Listen, because anytime I come out here to check it out. Or I think we're in the same closet.
Sandy,
2010
this is my new,
I love talking to those guys come out for one. find out where the gaps are. I'm hearing a lot right now. I think there's things that
Yeah, well, Taylor, I should have surveyed the audience, because Taylor, some more stuff to
soon I can.
Okay, I probably should go to the bathroom.
Hopefully we present towards like one of our events. So the opposite side.
Oh, yeah.
Very pertinent is people can hear my side of it. Absolutely. Like this MRI thing. Like, we can argue about it.
Yeah.
No, and it's
Causing me more related stress.
Yeah, I've done these before with medical providers on panel because there's such like a misunderstanding as to what your responsibility is. You know, and whether your responsibility as an occupational doctor is to the client or whether it's to the patient. And that's the problem. It's the same thing for us. Same thing for like an in-house adjuster.
Yes, very interesting.
Right, and she has a duty to her subordinates and her employees, right? And she has a duty to adhere to law as the administration of claims. So, same thing for you guys, where you just end up with all these competing duties, and that's why the reports, hopefully, you know, they come out truncated, directed, and
I'll show you a sample of one. New shows in town. It's just no one, no blow. Like, I'm getting on a transfer of care. How will you know where? That's
Yep. Good. No, it's good to have new people. It's good to be
no, and I want to believe this infrastructure talk. I want to believe this changes something.
Yeah. Yeah.
I was there for a while, and then I came over here. I've been here for 5.5 years. But this place, my whole and I'm I'm so tired right now. I have zero. I went to bed at 11. And I'm hot and I'm cold.
You just doing hearings over email?
Yeah, and I'm responding to a client, of course, who's
La 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 la.
the raffle. Everybody online has a ticket in there.
Okay, so the other thing,
You're not gonna win.
you're not gonna,
Huh?
What?
Dude, there's a lot of raffle back there.
No, that's not good news. I only have one in my pocket.
We
Yeah.
have lots of raffles today.
Yeah, there's
lots
lots of raffles.
Yeah, lots of
Okay,
raffles.
let's take a seat, pretty girls that are all beating each other.
Trish!
I know you're shy. I know you're shy.
Sometimes.
Yeah,
We're fine.
It's like herding cats.
that's true. That's true. We have two comments because obviously you could tell by our laughter that we had lots to talk about. Up here, I want you to notice the first two words, working together. It is a team. We can't do it without all those annoying case managers out of Shook and Stone calling us. We can't do it without the nurses. We can't do it without the vendors. We can't do it without the provider pimps. We can't. We just can't. Utilize your resources, and I understand that. I also understand that the new kids, who were hired in the last couple of years, and I'm sorry, anybody under 5 years in this business, you're an idiot. Because it takes you at least 5 years to truly see. And seriously, 300 years later, and I still have every single day, something comes up and I'm like, well, let's reach out to an attorney or let's try to figure that out. I still learn every single day. But the other problem is, and this is directed particularly at the seniors and the managers, the young kids don't have any idea what they're doing. And so what we've taught them is a process. We haven't taught them a profession. We haven't taught them a business. We've taught them a process. I have to push this button and this button and this button, and then I'm okay because it doesn't light up in my manager's office. They do not necessarily understand the relationship they have with their job.
The
And
intricacies.
I really hoped that when we got licensed, that people would take a better attitude and say, hey, I'm a licensed professional. Because you think about it, you can make $70,000 to $100,000 doing this. But you're a professional, and you take the risk when you take this job to also be held accountable to the statutes, to the regulations, and to the basic ethics of this business. Okay, that was it. That was the
Yeah,
conversation
so-
we all had.
Yeah, and it's along the same lines as what I was thinking. Just a couple more comments about, operating in reality. And that's what we're really talking about here. It might do better instead of having your new hires, for these claims assistant roles to interact with the claimants, right? And document notes of interaction with the claimants, rather than just push medical records around or just communicate with the doctors, right? There should be a certain amount of training that involves that, because what I see is that
People skills.
when a claims assistant jumps the med-only desk, which happens a lot these days, right? Because ain't nobody got time for that because we have so many claims, and jumps over to a lost time desk, right? Most of them haven't had interaction with claimants and don't know how to do that aspect. And if you lose that, there's not an easy way to track it, right? There's not an easy way to supervise for whether they're talking to claimants or talking to opposing counsel in the right way, right? And that new generation that gets built up doesn't have that in it.
And
Now
they
it's
don't know the law.
now and
Hand them a statute
right.
and tell them to read the statutes.
On the basis of the law, there is a current, an obvious current, that's pushing us in a direction that I promise you none of us want to go. And that's California. And we don't want to go to the way that California is. And neither does Kevin, right? It doesn't make any sense for anybody around to do this. But one unique thing about Nevada that not many states hold anymore is an exemption to the HIPAA requirements. So none of us have to deal with the HIPAA requirements like you have to deal with in California. And do you know why that is?
Because we're special.
It's because we're special and because we've maintained our speciality. No, it's because we are a highly regulated statutory insurance scheme. That's the exception to the HIPAA rule that's written out in the federal regulation, and that's why we don't have to comply with it. But you know what that means?
You have to comply to the law.
You have to comply with the law because you're viewed as an appendage of the government. And those who have been around long enough to have been part of the years before, the old days, right?
Good old days.
When CIS was around, right, understood that their determinations required due process, right? Because it was a government action, right? And whenever you have a government action, or a state action, it requires due process. But did you know that because we also have the joys of having our unappealed determinations become the law of the case, right? Through case law, the Supreme Court has found that. Did you know that we also have to follow due process, right? Which is provide the injured worker with notice and the pathway for a hearing, right, to appeal it, right? But it also requires abiding by the law, as Kevin was talking about, in regard to service of process. In fact, it requires us to communicate in a more highly regulated way than a civil case, where an insurer says, actually, your claim is denied for your car accident. We don't think our party was at fault, whatever it might be, right? They don't have to follow due process with that. They have some regulations that they have to follow, but not like what we do. Because we're a highly regulated statutory scheme here, we are acting as though we are the government. We are acting as the administrators of this statutory work comp policy. That's what the Industrial Insurance Act is. I said it 1,000 times when I was on the other side, when people came in and thought that their civil rights had been violated, thought that they'd been injured by their employer, were willing to fight for the tort, wanted criminal action. I'd have to tell them, hey, you've been led astray somewhere, and maybe it's just in your own thinking, because I understand how hard it is. But you've been led astray. What we're dealing with here is a no-fault system, right, that provides some benefits for you and doesn't give some benefits. And it's a great, big, grand bargain between your employer and you that you had no part in, but it was written out long before you were here, right?
Even before me.
And even before Ann. No, and because of that, right, because you're in this, hey, you don't have to worry about some things,
That's right.
right? And employers, because of this, you don't have to worry about some things. Nobody's coming out to sue you for the big bucks. But along the same lines of operating in due process, this creates a very comfortable place for us as adjusters, right? Where that we can speak about certain things to claimants and help to provide information, not advice, right? But you can give them the information. Everything that you do can be related back to a statute and should be on a claim, right? But I think that there's a tendency, because of this great current that pushes us forward, and because of the litigation increase, right, some of which just has to do with the economy. Our economy is blowing up. You think that we're not going to have more claims when we have twice as many employers in Nevada, right? When we add an employer who over 2 years adds 100,000 jobs to the Nevada market, right? Like, you think that the number of claims isn't going to go up? Of course it's going to go up. But we were just talking during the break, and I think that it's important to note here, your job as an adjuster is to manage risk, right?
Perfect.
It's to do what the statute tells you to do. It's not to save your boss money. It's not to save the employer that you represent if you're
And it's
insured
not your money.
It's not your money, right? What you're supposed to do is create, and nobody really talks about this, is to do it the right way so an algorithm can be created so that this is what's in your employer's best interest. This is what's in the insurer's best interest, is to create an algorithm so that people know how much money has to be dedicated to the payment of claims on a given risk, right? And that's easy to see with the insurers. It's more ambiguous when you're an employer, but the employer is doing the same thing. The purpose of your function is not to deny claims or to deny benefits. You will, by nature of your function, deny some benefits. Don't get me wrong. You'll get to that point. You'll probably deny a lot of benefits, right?
Based
Because
on expectations.
just based on the sheer volume of claims,
Right.
right? I mean, Kevin's going to ask for the long shot, right? And you're going
It's his obligation.
right? And you're going to deny that, but it's not your job to deny them. In fact,
And it's not
what your
personal.
job is to provide benefits.
Right.
It's to provide benefits to those who have been injured at work according to the statutes, and all those benefits that the statute provides and no others. That no others that we add in, right? That's sort of in parentheses. I don't see it up there in the statute, but that no others, right? That's enough for me and Kevin to litigate all the livelong day about. It was enough for the bar to be so much smaller and litigate about, 20 years ago, right? It's because of bad actors on both sides that more and more attorneys are necessary in this process, really.
Well, and regretfully, I think that also
And growth.
like we've talked about, I think that our side has failed in the sense of educating, and it came to my attention when we started doing the licensing, and they said, hey, take 20 hours of Texas, and then you can take the test. And I'm like, what the hell does Texas got to do? Not to mention the fact Texas has got one of the most unique workers' compensation ever.
Non-existent.
In fact, what did DOI have to do with any of it? Who wrote the test? What did they know?
So
Nothing.
I think that
we educated them.
I think that we have failed on our side in the sense that, the old timers we're trying, but the new kids, I mean, I have a set of, I print the regs. Every time you guys change them, I print them.
Yep.
And I have them tabbed, and let's read that again. Is
Well,
there
I
a
think
may?
it's a multitude of things,
Yeah,
right?
is there a may? Is there a shall? What is
Well,
it say?
so
I
I,
think the younger generation, I mean,
I love them,
obviously,
and I think.
we love millennials. I think I'm one. I don't even know. But anyway, I think I'm born in that age range. But I think the work ethic is definitely changed. Obviously, your older adjusters are more, sit at their desk for 12 hours a day versus your 20-year-olds who are like, I'm doing my 8 hours and leaving, kind of deal. I mean, I think that has a lot to do with it. But we also don't have training for adjusters. It's not like, you wake up one day and go, I want to be an adjuster, and then you go to school for that. That's not.
I'm working on that.
It doesn't happen. So if we could provide something like that, some sort of insurance training or TPA or adjuster training, where we could get decent qualified people and really train them on how to do the job properly and not learn like maybe on a computer or, how they're training these days because people just aren't available to train them. I think,
well,
it'd be
a
better.
couple of things. Now, that's actually a great segue into what NDPC provides. Because when I got on the board, this I think was back in 2017 or 2018, I had attended an event and I had noticed that there wasn't any representation of the injured worker, and so I kind of like, all right, I'm like, I will complain about things, but I also, I want to be involved.
I love it.
So I got on the board, and it was literally Sean and I's, that's correct grammar, first ethics presentation that we started to get a lot of traction, and we got such amazing feedback from the audience, and they were getting something out of it.
You
Okay.
remember that day, Katie? When
And
Katie
so,
came to
and
you?
then we went up to right, yeah, and then we
Remember?
went
And
up
she
to
was like-
Reno, and everybody got COVID, yeah,
Well, I got caught.
yeah, and.
We didn't get it.
Oh,
And
you did?
yeah, and so, but anyway, and that is one of our objectives is that when we do meet to decide what we're going to what kind of topics we're going to cover in these breakfasts and learns, there's some you're going to see that are repeat like this one, but we also are very aware, okay, that the industry needs some training, and so why don't we try to provide what we can? And so we're always, and this is where it's much more going to be claims centered than the law. About what does the field necessarily mean, or what would it be beneficial, and what could we potentially offer, and we have enough industry people. Now, I disagree that there is a current, as it's been described, that we're moving towards California law. We're not even close. Expansions of rights, because of the great work of the Nevada Justice Association, which I'm a part of, doesn't mean that we're, that there's a tide necessarily turning towards California law. Certainly, if the hearings division gets revamped and it operates like a real court, that might be step one. But the employment laws are so drastically different. So I don't really see that necessarily, I don't really see that going on. But I will tell everybody that every 2 years with the Nevada Justice Association, we have, like, the bills that we proposed, not one person voted against it. Okay, so this is the entire group of 2 years ago where, the Nevada Resort Association, they sign off on these things, that the injured workers, that the rights, at least of what we've worked on the past couple of years, we expanded those rights to make them more reciprocal and not so one-sided. So certainly the case law, we have a Court of Appeals now, and so we're getting some more case law in workers' compensation. I think 100%, I think, of the cases have been cited, have been ruled in favor of the injured worker. Anyway, so that's certainly my opinion. Our opinions differ on the current or what have you, but that's just a little bit of food for thought. Now, the training pieces, certainly I'm all for, like, the more training in the field for the adjusters. My interests are much more, if people know more, then we, litigate, less. And what that equation is, I don't know, but certainly this organization is living proof that we are listening and we are aware of the industry challenges. And so what can we do to provide some sort of guidance or assistance and or training? And we do that.
I think that this definitely is an opportunity for us to drop an anchor and not flow into a fully aggressive civil type arena for our litigation. And I don't think anybody really wants that on either side, but it requires a lot of education and it requires a lot of training for the new individuals, for everybody that's coming in, because it's going to take 3 to replace every one of these Gen 1.5ers, because I don't think Generation 1 is still adjusting claims or doing it or even participating in the industry. But these Gen 1.5ers that are doing the training right now, it's going to take a lot of training and a lot of investment where that you're not really hands-on with claims, but just training individuals how to work the claims. Otherwise, we're going to see reserves go through the roofs. It's not going to be good for anybody except for the
fact that
the
everybody's
attorneys.
working from home. It used to be where you had a question, you leaned over the cubicle and said, "Hey, Ann, how do I handle this claim?" And then Ann told him, and then it was done. But now they don't have that. Now they just have the IMs, and sometimes that's not.
And
always...
and that's critical. And that's one of the things that I established at Corvell is we have a Teams. I call them the superstars because they are. Duh. A superstar Teams meeting, and every morning we all sign on, and then all day long, hey, can you verify this? Can you look at this? And we ask questions amongst us, and that way our younger get the expertise of some of the phenomenal.
So you feel like you're in the same room?
Yeah, and it really does. And we'll talk about vacation as well as claims.
Yeah.
So it's a very casual discussion, but you can ask your questions, and you don't have to wait. You don't have to see if I'm going to
The
answer my
beautiful
phone.
thing is it's always logged, so you can always go back and look at it.
It
So that's
is,
exactly
but
right.
that just brings up a point that's very noticeable. Some organizations that were not working from home, and then the pandemic hit, and now they are, or there's a hybrid or something, what have you. There certainly were growing pains there. We still have found out information that adjusters sitting at home, you have no idea what's being sent out. Okay, you have no idea. Did that get sent out? Well, I don't know, the assistant said they did. Okay, but like we are finding things like that out, and so through depositions and things like that, they're like, oh, so none of this stuff ever comes to you because you're sitting at home. Okay, how would you then know that this went out? I mean, certainly you work collectively, and so you have to take people's word for it if they say they do their job. But those are things we're finding. I will tell you, okay, and this is again just me personally. We have really struggled. I don't know what you think, but we have really struggled down at the hearings division with this new way of doing things. Okay, because for whatever reason, the hearings division has taken a position, and again, to each their own. I'm just telling you, I don't like it. They've taken a position that they can't compel people to come down there and show up in person any longer. Okay, well, I'm going to tell you that. Prior to when all of the attorneys were generally down there, again, that's between you and your own client, okay? If you are hiring a defense attorney and you don't care that they're sitting at their desk the entire time, that's up to you. My client has different expectations, okay? And certainly not everything do we need to show up for, okay? But when we were down there, okay, not only were we down there talking about this hearing for the hearing that we were there for, or hearings, okay, there was so much more dialogue. We were talking about so much more in so many other cases and what have you, and that is literally gone, okay? And so I'm going to tell you right now that there is not, and you can attest to this, sometimes the attorneys and the judges will kind of admonish us for sometimes not talking, well, imagine now this environment, we're not even seeing each other.
That makes it hard for the new attorneys, just like it makes it hard for the new adjusters, right? They don't have a chance to meet the other side, to see that we're all people and see
Right.
that
Here's
where we're coming
Now, as you're talking about the more claims and what have you, here's a fun factoid, okay, is that, and some of you may know this, for whatever reason, lawyers don't want to do work comp. If they do, they kind of dabble in it and they get right back out, or they just do it as a side note to their PI practice and then they screw up and commit malpractice on a lot of the work comp claims. But that is another reason is why my colleagues, it's so unique. We don't fight over cases because there's enough to go around, because we don't really have any new attorneys coming in to do workers' compensation. It's kind of the same people. Now, I love that. You have a little protectionism, type of thing. But that's another element of what's happening. So I don't, as you have heard me, I believe that the hearings division is a big problem, and they have contributed to a big problem. And this is something no one, like you said, it's in no one's best interest for the court system not to be operating properly, or for there to be delays in the court system. I mean, that doesn't help anyone, okay? Yeah. And there is definitely common ground there, but it is going to take some significant revamp.
Yeah, I mean, I think that all of us tried to, whatever you want to call it, by the seat of our pants, just roll with the punches that came over the last 2 years, trying to turn a government bus. Virtually nothing changed other than the fact that we weren't going in, right? And for some reason, even though nobody was going in, they put up all of these plexiglass structures, which didn't make any sense either, because there was nobody there. And by about the time that people started going back in, or attorneys started going back in for hearings, the plexiglass was coming down. So it didn't make any sense what happened over there. They also made some adjustments to the workspaces, and yeah, I mean, there was a lag, which is totally expected, but has been really hard for us to deal with down in person. It's changed everyone's view of what their ethical responsibility is, right? I think that everybody's a little bit more okay with being closed off, a little bit more okay with letting it go to voicemail, and then getting the call back if and when they want to, and we got to get out of that. I mean, if we're going to really do a good job at towing the line in regard to our ethical responsibilities, if we're really going to do a good job at our job, and not have to have a system that totally changes, we're going to have to get back from that. We're going to have to get back to as close to face as you can be with these claims.
Even with these meetings, we'd always love to do them back in person. Trish will be the next upcoming president, and Trish is dead set on going back in person. So I wouldn't be surprised if we do not do online and Trish, or only for Reno, and Trish is like, no, it's gonna be in person, because we miss that networking. We miss you guys meeting the adjusters and having a conversation and realizing everybody is human, and that everybody has a job to do.
Right, but we've been spoiled, right? With technology. If we used technology the right way, I think that it would have been a real fix. If I wouldn't have been going down for hearings nearly as early as I was, and I was one of the very early ones, if I could have relied on technology. And if it was just as easy to FaceTime with Kevin before a hearing, then there would be no problem with it. And what we have here is really good for doing a situation like this. This is exactly what Zoom or what Teams was created for. Doing hearings, litigating in front of in front of an appeals officer or another tribunal, it just doesn't work that well. I mean, even in, what was that movie? Was it Judge Dredd? One of those futuristic movies. Even in those movies of the future, you still had the parties that were like in the same room. Right. It was just the judges that were up on the walls. But we didn't really have a good solution to that. I think we did GoToMeeting, and
we taught them. Dalton and Adam and I taught the hearings division how to use GoToMeeting, which is like a Zoom. It's like a conference, so we could do hearings by video conferencing.
But it didn't ever really work. I mean, there's all sorts of problems because you're trying to get 3 or 4 or 5
Why is the private
parties.
bar teaching the state? Like, I didn't.
But with all that being noted, the difficulty is on us. Our ethical responsibilities don't change just because the environment that we work in changes, right? Just because we have new hurdles that we have to jump over. That's one of the reasons that in the practice of law, they've established these ethical canons that basically model each other in every state and create the bedrock for how that we act in a professional and ethical way, both to ourselves, to our clients, and to the tribunals that we practice in front of, and to the public at large. And we'll go through some of that. What's interesting, as I said earlier, we always joke that one of the reasons that they had to come up with these, and everybody else kind of jokes about it, is that we don't have our own personal moral compass that could guide us in an appropriate way. But the truth is that this is becoming more of the norm. More and more industries are adopting rules of professional conduct and ethical regulations because there seems to be more and more wavering as to what is ethical conduct. And I think that, as we stated before, the putting on the hat of representing somebody else causes conflict with that. A world that's based in internet communication has provided real problems with that as well. But it's become more and more necessary across the board. One of the places that they've adopted these standardized rules of ethical conduct is in the administration of claims, specifically in work comp, but in all insurance claims. We'll go over some of those today. It's the reason that we're here. So because some of you might have lost your moral compass, and so the state's requiring you to do this now as well. So we'll just go through some of the slides so that we check off some of the bullet points. So professional responsibility is the area of legal practice that encompasses the duties of attorneys to act in a professional manner, obey the law, avoid conflicts of interest, and put interests of clients ahead of their own interests. Legal ethics encompasses an ethical code governing the conduct of persons engaged in the ethical or in the practice of law and persons more generally in the legal sector. That's basically where that you come into play because, as we stated before, governed by due process, you're a highly regulated scheme, and you are operating in the legal sector. Legal ethics in the United States is generally understood to primarily apply to lawyers, while codes of professional conduct or professional responsibility also apply in a derivative sense to non-lawyers, indirectly to non-lawyers who work with lawyers such as paralegals, industry professionals, or investigators. In the United States, the practice of law is regulated by the governments of the individual states and territories as a whole. State law and professional organizations, as opposed to federal law, controls legal ethics. Each state or territory has a code of professional conduct dictating the rules of ethics. These may be adopted by the respective state legislatures and or judicial systems. The American Bar Association has promulgated the model rules of professional conduct, which, while formally only a recommendation by a private body, have been influential in many jurisdictions. Our rules of professional conduct in Nevada model them almost exactly. They change some of the verbiage, but the actual structure models the model rules of professional conduct to a T. Nevada Bar Association developed the Nevada Rules of Professional Conduct, which are adopted by the Supreme Court of Nevada and govern the practice of law, enumerating the baseline levels of moral conduct for attorneys in Nevada. Does anybody have any questions about attorney professional conduct? I mean, I'm sure y'all have a lot of questions about it, but do any of you have any specific questions about attorneys' professional conduct or ethics? It's weird, right? The way that attorneys operate, the way that you operate. There's somewhat of an inherent conflict, it seems, in representing somebody in the practice of law in an arena where that you're not appointed, right? Because at the end of a claim, this is Kevin's favorite part, I'm sure, but at the end of a claim or at the end of his case, Kevin has to ask for a whole bunch of money from his clients, or a little bit of money, and they still think it's a whole bunch of money from his clients. And on the normal, we have to bill our clients, right? And that's the two ways that you basically operate. And so that puts you in some sort of, it seems as though it puts you in some sort of a conflict. That's one of the reasons that you have these ethical rules to govern that.
Oh, yeah, sure.
Yeah, I'm trying to get the tech up and running, but it's not right now. But I mean, why don't you speak to that a little bit, Kevin, about how it goes at the end of your claim and whether or not that provides you with an ethical dilemma in talking to your client?
So I'm going to just give you some specific examples. I shared these a couple of years ago when we did this, and I think it really surprised everybody that the ethical responsibilities of attorneys in work comp versus the plaintiff's attorney versus the defense attorney are actually vastly different. And it is, and I am, number one is, let me just throw that out there, is that I will tell you in workers' compensation or personal injury, we seem to, and I know this from having discussions with defense counsel, the complaints of my own clients going to the state bar and complaining that I've allegedly done something unethical doesn't seem to really permeate on the defense side, because I don't know, I mean, maybe you all have, but if your attorney made a mistake in a case, if you know about it, do you go and file a bar complaint against the same ones you use over and over and over again? So that's always, again, that goes back to, managing the practice the way I, see fit and the way I think it's ethical. I will tell you is that I have to be very careful about conflicts. And when you say conflict, okay, well that's just a very kind of, laundry word. But conflict meaning is the client wanting to do something that I'm in disagreement with, okay? And that is a big difference between defense counsel and what I have, okay? So I'm gonna give you an example, okay? And I think this would surprise you to hear this, okay? And if there's a conflict, if there is a real conflict between my client and I have to withdraw from the case, okay? And the conflict is very vast. I'm gonna give you this example, all right? I have the group of doctors, say for the spine, that I use, okay? And the person comes to me. If a person comes to me and hires me, it's gonna be done my way. Why? Because I have an ethical obligation to the state bar as well as to them, okay? That they don't tell me what to do, okay? Because that is unethical. So they're gonna do it my way, so I'm gonna say, let's pick one of these doctors, and then they go to the doctor, okay? And then they don't like the doctor, or they don't, something along those lines. They wanna switch doctors, okay? And I say no, because number one, why would you take a person just because you don't like the doctor or whatever? Now, again, there are some exceptions, what have you, but for the most part, no, you're gonna see this doctor, the doctor's giving you care. God forbid I do what you say and I send you to this doctor and they say, okay, you're done, MMI, you're done, and you get nothing, okay? That is a conflict. So does anyone know what the end result is there? Like if they say that, hey, okay, no, Kevin, I wanna see Dr. So-and-so, okay? So make it happen. Guess what, do I? No,
Oh, no.
I don't, okay? I must withdraw. That is a big difference on the defense side for the plaintiff side, is that it's done, and I call it my way or the highway, if you will, okay? You certainly have dialogue and you're talking with them about the claim, but it is set up how I want it to go, and that's why you hired me. If you want to go a different direction, that's fine, but I can't represent you. You can't be driving the train and me sitting in the caboose, okay? Because that is unethical. So, and then if the case gets screwed up and you screw it up, and I'm sitting there going, told ya! That's not how it works,
Right.
okay? So a lot of the times, certainly if I can't contact the client, I have to withdraw. There's a lot of different instances where, and again, this is where we also have to protect confidentiality. So say I can't find my own client, I can't go, or say the client has said nasty things to me and I'm just leaving because I don't want to represent the person anymore. I can't go in and disclose that information to counsel or the court, okay, because that's confidential. So there's a lot of ethical obligations that I have that many people are not aware of that only really happen in the plaintiff side, that are big differences in ethical responsibilities. So I just share those because it is a different type of practice and a different type of approach.
Right.
One of the adjusters says, when they want to switch doctors, I cry a little inside.
Yeah, I mean, it depends. I mean, we certainly have not all doctors, gel with every person and all of that, and I get that. I just look at what is happening with the care, and certainly, have I worked with the doctor before? And things like that. I mean, that's what I do, and I'm almost positive my colleagues do the same. Like, they cannot be driving the bus.
Mm-hmm.
Right. I mean, and the reason for that is that when you have ethical standards that are promulgated and by the government and that are that are required of you by law, right? Then it holds you to a heightened standard than the general public. That's why that Kevin has to make the decisions, because at the end of it, if he doesn't have it documented that his client basically fired him off from making certain decisions, then the courts are going to refer to Kevin's actions and hold him to the standard of a reasonable attorney, which is different than the standard that the general public would be held to. Along with requirements for education that we have that help keep us to that standard, and that you have as well, you are held when you operate as an adjuster or as a participant in the administrative process here, you are held to a heightened standard as well. The ways, I'm going to just hold on a sec. I mentioned technology a couple minutes ago, and then it just went crazy on me. And I think that we are.
It did. It came up.
We good?
Yeah,
Okay.
it's up here.
So the different ways that attorneys are governed in the state of Nevada are parsed out into 8 separate sections, and they cover almost all the same rules that govern you in administering your claims. Those are client-lawyer relationship. Who here knows when a client-lawyer relationship is established?
When you say hi.
When they sign the paperwork.
Interesting answers. Someplace in between there, probably.
Yeah.
Anybody else? How many of you have lawyers? Are clients for lawyers right now?
What?
How many of you are clients for some lawyers right now?
Like, who has cases?
Who has cases that are being litigated?
Everybody open it, no.
Right? And do you know when that relationship starts?
When both parties agree.
It's interesting. That would be a good one.
When I hired him.
It is the sooner of a written agreement or when any legal advice is offered. So if I go to a party and someone's like, hey, I got in a car accident, they T-boned me, and I say, you know what you should do? You should file a lawsuit. I am now their attorney. By statute, right, or by regulation that's been sent out by the bar and adopted by the Supreme Court, I am now their attorney, which gets folks into serious
I know
problems.
we talked about this before, but it's true. Like, if you're at a party, somebody can do that.
I
and
mean, the
then-
caveat, you say, I don't represent you, but,
Yeah.
I mean, there's.
You try,
yeah,
right?
Yeah.
Oh,
and-
you can say that in your.
And how are you going to
Of course.
document it?
Yeah.
But there have been cases
Yeah, there
that you
have.
go through in your professional responsibility courses that there have been cases where the Supreme Court has found that at a party,
Yeah.
you offering some legal advice, 2 years down the road, you are responsible
Oh my gosh.
for the legal mistakes or failing to file that complaint, failing to file the lawsuit. And so when you call up your attorneys on a claim that you haven't referred, right? Which I'm not complaining about this. We're free to provide, consultations and things like that. Just understand that you have developed an attorney-client relationship when we give you that free legal advice that we're giving you, right? And it probably ties to that claim. And so if you decide to go with a different attorney, right, and you don't advise the prior attorney, right, then there can be some conflicts that develop. And if I give you that legal advice, it's probably not going down in my software anywhere that checks for conflicts as to whether I do have a conflict. And so then if you have a dispute with your TPA, right, or if you have a dispute with the insurer as an employer, or vice versa, right, your employer comes to me, it's probably not getting flagged, and so there can be an inherent conflict which develops where that I've given you legal advice, and then now I'm representing an adverse party. We don't represent claimants at my firm. Some firms in Nevada do. I don't understand how they avoid conflicts in that, because there's kind of been historically too few participants to not have active conflicts there. But we do represent employers, right, in actions where they might not agree, and so we have to be cognizant of that, right? And so probably the best case is that if you get consultation on an issue from one attorney, you probably just stick with that and consider that as when they took the file and when the attorney-client relationship developed. Was there a question?
Yeah, is
Trudy?
this all true for physicians, for doctors? You're at a party, you come up and you're talking about some,
No idea.
Yeah. So one of the things we'll get to is competency, and I am absolutely incompetent to advise you on that. I don't know. We do have a medical doctor
Yeah,
in the
me neither.
audience.
I'm not a lawyer.
Yeah. Oh, whoa. Now you're in limbo. Now you're in limbo. He doesn't know if he's your
I
physician.
don't want any relationship with anybody.
Yeah. I think, and here's me out on a limb, not providing any sort of professional advice to you, but I think that the same holds true if you receive medical advice from a physician, then the duties owed by a physician to a patient are owed to you at that point from that physician. Now, they don't run into conflicts like we do, because they aren't as they don't fight as much. They do sometimes, but not as much as we do. And so if you went out and got another doctor,
The best physicians, I would say, will do the same thing that, like Kevin said. I'm not your doctor, I don't know your medical history.
yeah,
But in general, here's where I would go in that direction. They're not gonna put themselves in a position where they're gonna make themselves liable when they haven't had time
and
to
advice.
review that medical history and.
Right. And advice and information are two different things as well. And you'll see medical doctors do this, and we do this as well, where we say, yes, you may be able to file, like if somebody comes up and asks us about a car accident, you may be able to file a claim, or you might have a cause of action in regard to that. If you were to pursue that, you'd need to go, to these courts, right? To that, and so you can kind of toe the line. It's never a good place to be in by offering advice to your friends. or
No,
family members.
you know what? I've stopped at those little casual conversations at the airport when they ask you what you do. I'm a performer. Like I don't.
I should use that. I do.
Because every Uber drive I'm in, that is the joke
God.
amongst
Oh,
my
my
inner
sister.
circle of friends, is that Kevin cannot get away from legal questions, no
Legal
matter
questions.
who it is, no matter what it is. And of course, it's always about stuff I don't know anything about. So it's easy for me. I say, well, I don't know anything about that, sir. So no relationship there.
Sorry,
Yeah.
I call you all the time, Kevin.
Yeah, it's just a different theater that we're
No,
in.
no,
right?
no.
Guilty.
No, God, no. It's par for the course. Literally, yeah.
So,
Except for I wasn't drunk at a party.
right,
I
right.
just call him Kevin. Hi.
Well, that gives you a problem with competency,
Right.
whether you could have started an
Right.
attorney-client relationship. Second area of professional conduct in Nevada is counselor. This goes into what Kevin was just talking about guiding your client, right? About providing that counsel to them and then counseling with them to make the right decision. Ultimately, the ultimate decision ends up resting with the client. However, the way to get to results that further that decision are all on the attorney. And so there has to be a counseling or consulting aspect to your job. And that takes up, I'll tell you, with Kevin, it takes up way more time out of his practice than it does for me.
Right.
Having done what he did in a smaller portion, it took, I don't know, 80% of my time was spent counseling with clients and helping them to understand why they weren't going to get $1 million. I don't know why that number became like the number. Like they if they were injured by a corporation, right, which they think they were, right, whether it's their fault or not, it doesn't matter, right? But they would come in and think, I'm making $1 million. It's the McDonald's case.
Or they're never going to work again.
Yep. Oh yeah. But they think that they'll never work again, even though we have it. Like teaching
No
them about
surgery,
right.
right, yeah.
Teaching them about vocational rehabilitation opens
contusion.
doors, right? But that's all in that counseling process. And so the legal advice, right, aspects of that attorney-client relationship, it really does just sort of like merge all together with the counseling. And you have to have goals in both regards. Otherwise, it just won't work. And so when you hear Kevin call up and say, my client is never going to agree to that, we got to figure out a different way to get them to do X and Y, to see XY doctor, to go through a detox program, whatever it might be, right? Then you understand that he's got these two conflicting responsibilities of, hey, I need to do it the right way, and I need to abide by the law and be the guide for my client, but I also have to counsel with them and get them to a place where they'll commit to do these things that are right for them.
And that's when I talk about the counseling being so crucial about people skills, because you can't counsel anybody if they don't like you. I mean, if they don't trust you, and you're talking, for me, they may not meet me until sometimes down the road. We have this like gorgeous flight attendant video. They meet an attorney to sign up, but it's usually my associate, okay, or an attorney that's in PI. And then we have this gorgeous video of me when I had less hair, and goes through all the here's what you need to know, in the next 30 days, because if they don't see that video, all of a sudden 2 days later, what's the status of my case, and I haven't even sent the rep letter out yet, something like that. But being that counselor is a hat we have to wear consistently. And it may have nothing to do with the case. It might have something to do with the employer. It might have something to do with their ex-wife. It might have something to do with an injury that you know nothing about. There's just so many things that are laid with you. Well, like Sean said earlier, well, I didn't cause this accident.
Right.
We know, or we're tripped up on facts of, well, do you need to see the photo, of the accident? I'm like, well, we're a year into it, so not really. But again, the guidance and the counseling, for me, it has to be genuine. And yeah, I mean, people are shitty to us. I'm not gonna lie about that, is that, you know, our practice, Shook and Stone, is a full service disability law firm. So we do personal injury, social security, disability, and workers' compensation. And there's no question the workers' compensation clients are the most challenging. You know, and it's
And
our
you're
job
murderers?
to guide through. We don't do that. We don't do that. And so, but there's no question, right? And that's our job. And sometimes it just takes. And here's the other thing too: is that I've got great staff. Okay, that is again why I'm a part of the success that we have. Is my staff are amazing, and they can say the same thing I'm saying. Okay, and the person then I say it, they're like, okay. Okay, so we deal with that, where for whatever reason, an attorney says something, then it's better, or what have you. And, you know, and a lot of times they'll say, well, the way you explained it was really great. Well, right, I am the lawyer, and I'm the one making the big bucks. So, yes, I mean, that's a skill set that I have. Shook and Stone didn't teach me that. And so, you know, those are things that, you just have to be
But it's an
genuine.
obligation that you have, right?
Right.
So they can't teach the counseling aspect of the job.
Right.
But you have a requirement to be able to counsel with your clients, and your staff does not.
Right.
Right. And so that's why that you end up with this, like, being able to pull some of these things that you couldn't before. Understand that there's a requirement for that counseling aspect of it for you as adjusters as well. So transactions with persons other than clients, some of that gets into conflicts, but some of it gets into things like attorneys can't make like a transaction or an agreement with another attorney in their office that would say you're not allowed to go and solicit cases against us, you know, later.
Non-compete is
Right?
what's called.
Non-competes,
Yeah.
right? They aren't enforceable because what that they've done here is they've said, hey, we're going to limit your ability to contract out of your relationships or around your relationships or in conflict with your relationship with your clients, right? And we'll get to some of the ways that transmutes into your industry as well.
We do run into, well, we haven't, but there's certainly, because work comp is a small group. So if you hop around, or if you go, certainly from one defense firm to a plaintiff's firm, or vice versa, or even from one defense firm to another defense firm, I mean, there are certainly real, what we call conflicts of interest there, where you have to screen people off, and there are these specific set of criteria that the state bar, looks towards. It's very gray. I mean, I'm sure you know this. That you think it'd be a little bit more clear cut, and so there is that issue where if you have lawyers, including staff, and the case law is clear that staff also are impacted in regards to conflicts. If you go, like if you work with me and you go to a defense firm, well, obviously you can't work on my cases, okay? And so I don't, because Shook and Stone hasn't done that. I've been there forever, but that does come up.
And it
people
gets
move around.
and it gets
Or if you
very.
have an adjuster who moves from a self-insured employer or something like that, and becomes a case manager for you, they should not be
There could be,
working on
right.
cases for that employer.
Well, it's weird, right?
Yeah.
Because and so work comp
I wouldn't. but-
again throws a wrench into it, because it's like, well, you have claims that you have a lawyer, a client relationship to, right? You have your clients. Who is the client? Is the client my adjuster, right? Is my client the case manager? I develop intimate understandings of the way that they process their own style and things like that. And so, many moons ago, you'd only have, a few handfuls of adjusters, in the state. And so if you switched sides and went and practiced, well, then that's everybody, right? I mean, if you have a conflict of dealing with them. So it's probably not that, but if I'm representing on claims against, say, Gallagher Bassett, right, and at Kevin's office, then I switch back over to defense. Do I should I be able to represent Gallagher Bassett, or does that leave an environment where I might use my specific understanding of Kevin's cases to influence? And it really comes down to the attorney walking that razor's edge. The bar doesn't really give you any help with that, and if you call up, they still won't. What they do is they take a cookie cutter civil suit and they say, you can't be on the other side. That's a direct conflict of this. You can't represent the plaintiff and represent the defendant. You can't represent the plaintiff and then go represent the defendant, right? Whether you can switch between two plaintiffs is even gray in that, even though you know that there's an inherent conflict at the end of the case, likely with that. So they provide you with some guidance, and then they leave it up to these morally repugnant
Right.
individuals to try to
Hopefully
figure
we
it
made the right
out
choice.
themselves. And so one example of when this happened in my career, not a personal example, but I don't know if you know about the story with an attorney in our office was moonlighting, running a personal injury practice while that he was doing defense work when we were over at a prior firm. And we didn't have any real interaction with our group, with Dalton and I's group. But he was upstairs and we knew of him. And he would come down all the time and try to get like little lessons on work comp, which always seemed a little bit weird, but we were like, okay, we're pretty cool.
Right.
Like, just like Kevin just said, people don't usually want to know about work comp. So we're like, so everybody would kind of like, okay, we'll like teach you about this or that. Well, he was trying to specialize in some work comp cases, not understanding how small of a market that it was. And so we ended up getting sued on his letterhead from upstairs. He didn't realize he was sending the letter to his own office. So he sent it out in the office mail, and then it came back to the office mail and came to my desk. And then he realized that he sued his own client with his, or threatened a lawsuit against his own client because he'd been moonlighting doing personal injury. And so we shy away from that. That's like just an accidental conflict that arose out of a firm. Maybe you'd call it a negligent conflict. It wasn't my doing. It was really awkward when I had to go and tell his boss what was going on. It was really an ordeal. For some reason, he was a younger attorney. He didn't think that there was a conflict, that he could run two firms that suit each other. But needless to say, they have these rules. Some of it's cut and dry, what you should do, and some of it's not so cut and dry, just like the examples that we're talking about earlier here. Law firms and associations, basically my ethical responsibilities go out to my law firm. For conflicts, they have a weird function in law, and I don't know how that you say it with that it being like a insensitive term, but you can put up like basically a wall. You can screen yourself off. In law school, even when I went, they used some pretty racial
derogatory
term
yes.
for it. But that you can screen yourself off, and you can fix some conflicts in certain ways, and you can't fix others, and that's there. It becomes like a dicey thing in a law firm. If you have a direct conflict, it doesn't work. If you have a potential conflict, you probably can screen yourself off. But it's probably difficult for me to represent an employer in a claim that's litigated where that my office represents the insurer and where that we have adverse interests, which sometimes arise. So we probably can't do that, even with screening off, because we're inside that same action together. Now, if we represent an employer in other actions, and they happen to be a party in this, right? They have other counsel in this claim or in this litigation, then we probably can screen ourselves off and just not give access to those files or anything, and as though we were never touched by it, as long as we have the proper measures in place. And so now you can see why that we need the guidelines, right? Because something that, like a potential conflict, something that might seem as though it would be harmless and very well could result in being harmless, may have the potential to do harm, and so the public has to be protected by these.
I had a file where the employee worked for Quad County School District, and then she worked for Las Vegas Valley Water District. She was actively involved in treatment and litigation when she had her subsequent claim. It just happened to be with the same TPA.
Right.
So it wasn't until we did a search, because they can't just come say, oh,
Right.
by the way.
Yeah.
So, and then when it went to litigation, we couldn't even send it to the same attorney because I was representing
Well, he's still representing,
on
right?
the
And
other
so
claim, and now we need a new attorney to represent on.
it's probably the biggest place that we get conflicts in work comp. Those direct conflicts is when that you have a last injurious exposure issue. And I think that most of us have a few of those on our desks at one time. Puts Kevin in a really weird spot because he's like, I don't care. I just have to pay the money. I don't care. And so the litigation kind of can be extensive with that because you're litigating over who kind of buys it, and then, but you probably, I'm not making the decision. You probably shouldn't have the same attorney that's representing on both of those. And I know that
Or
in
the
the
same
past,
office.
Yeah.
That's my opinion. But again,
Yeah.
this is where you can adopt
Yeah.
your own ethical rule. You know, I mean, but
and I know that in the past there have been some attorneys that have been comfortable with that. But as more and more attorneys enter the market, as we grow, there isn't really a reason that you don't have conflict counsel at this point.
I want to
in
say that
Nevada.
don't you can get written like if there was a last injurious exposure rule, like, and say you had both claims,
Yeah.
you can get written consent, like it's called informed consent, so it has to be in
Yeah.
writing, and both clients saying okay, then I think you can proceed. In the criminal law world, so say two people commit together commit a crime, we are forbidden to represent both co-defendants, so it has to be only one, and they can't waive that in any way. So.
And the truth is true, and the truth is true, and the same is true of claimants as well, and plaintiffs, where that you would have one bucket of money. Claimants, you wouldn't have the conflict as often, but if you have like a third-party claim, then there's a potential for a conflict at the end of it, and so you'd have that same you have to have that foresight to recognize that there's potential for a conflict. Otherwise, you may be in violation of your ethical rules. Public service, they want us to do pro bono service, and we'll definitely get around to that.
Are you guys required to do pro bono?
Not in Nevada, we're not,
No.
and it's sad that we're not. There's all sorts of different ways in other jurisdictions that you can meet that. You don't have to like take on cases. You could just do trainings. This probably would be considered pro bono service right here, educating the public on attorneys' responsibilities. I did a class like that when I was in law school. We had to do a pro bono clinic type thing, and ours was like
But
a
you don't have
bankruptcy
to
deal.
like CEU submit pro bono hours.
No,
Not
you
pro
can.
bono.
I really don't understand why they have the form even set up the way it is. It's like, did you want to? Here's your requirement if you wanted to.
Here's
And
your
then you could
requirement
click
if you
no.
want to.
But the problem is, like, you could count them up, and I don't know if I'd be, like, so I've always clicked no on it because I'm like, I don't know if I meet their requirements because nobody ever really educates you on them. But some jurisdictions do require that. We have we're admonished to do it, right? Like, they ask us to do it, but I don't think that there's really a real requirement. Now, there is a requirement that you're willing to. And one place that you are required to do this, or you could have problems with the bar, is if you're appointed. That is beautiful. Thank
That
you.
was perfect timing.
I don't know. If you're appointed.
I don't know this. Sorry, someone's cell phone was going off.
Yep. But yeah, so you can be appointed. So like NAIW is required to when they're appointed to accept public service, and attorneys are required to accept appointments, which happen from time to time when I clerked for a judge, where that an attorney, you'd have a conflict with the public defender's office, and the judge would just still doing it as of 10 years ago or so, or 12 years ago. The judge would just pick a criminal defense attorney out of the audience and say, hey, actually, you're appointed to this case right now.
OMG.
And
Don't show up to court.
and it could be a murder trial, right? I mean, it could be a murder
Oh,
trial that's
wow.
going to take up 2 months out of the end of your year or whatever it is. And so they still do some stuff like that. If you're appointed by a judge or public official, you're required to take on that appointment and provide the service as they direct it. So information about legal services, that's marketing. That's why you always hear us say, hey, I can't give you a real answer on a likelihood of success on a case. And we always bounce around it saying, hey, I think that you have a good case, right? We say things like that instead of saying like, oh yeah, 90%, or we got this in the bag, or there's, this. I've won this case 1,000 times. Just give me the case, and we'll do. Nobody's really doing that in work comp because we've all got most of us have enough cases. But but as far as marketing's concerned, now I don't know what they've done or how that they've toned this back lately. But the marketing used to be like, you couldn't be like aggressive or like look like you're violent, and like now, and now there's like billboards of people using dogs and
Bats
things like
and
that, and bats and things.
The heavy hitter. Oh.
Yeah, I mean, I don't know if that. I
Probably
think he did
shouldn't
away
have
with the
said that
bat,
out
but
loud.
like there's a few of them that you see out there. Like I think there's one that practices with us that I wouldn't have thought would have been able to use the name that they use. Have you seen? I think there's like a Sin City law that like
Oh,
that,
okay.
that like is interesting. I think the bar has become more relaxed about some of the marketing rules, but I don't think that 10 years ago the bar would have let you be like Sin City law, which like because I think some people had tried it and they said no. But anyways, there's rules about that, and then maintaining the integrity of the profession. This is where like if you're a DA that gets caught with a trunk full of cocaine, you end up getting disbarred because they hit you with that.
Minor detail.
They hit you with that caveat. In
Or
the back
you,
there.
yeah, or you are a lawyer and your boyfriend is Sereno, which is
Oh my
a
God.
gang
Yeah.
member, and you're using your privileges to go into the what we call contact visits down at Clark County Detention Center, and you hand him your phone to utilize your cell
Right.
phone in there. She also was disbarred.
Yeah.
Well, this
Um,
actually happened.
Oh,
I
yeah,
did remember
yeah,
that story.
Yeah.
Oh,
So
yeah,
I mean,
I
these
do
are again,
remember
these are
that.
horror stories, but
But
so
that's-
certainly
that's-
that tells you what's out
right.
there. You know.
Has to catch all. There's a reason for every one of these rules. Every one of the model
just
rules,
crazy.
the specific rules. I was involved in an organization, a long time ago, where that a president came in and threw out the rule book. Was like, we don't need any rules. We don't need this big policy manual. Why do we know this? And then within about a year, it was verging on the same size because it's just every infraction requires attention. And then needs a bright line rule. Otherwise, people just think they can get away with whatever they want. It's the double edge to having these rules is that people will violate even the most commonsensical type standards if they don't have a rule for it. Once that they get a rule.
So we have about 10 minutes, give or take.
Oh, cool. Well, we haven't talked about anything yet, so that's
Okay,
good.
cool.
Here we go. Okay. Really quickly, adjusters have the same types of rules of professionalism and ethical standards. They are brought to you at NRS 684A 165. I'll just read through them. I think I've said this before. I think every adjuster, every person that's employed with an employer in this type of a capacity should have these someplace where they can see them. It really does rein in what your responsibilities are. An adjuster shall be honest and fair in all communications with the insured and the insurer and the public. The insured, the insurer, and the public. The adjuster shall give policyholders and claimants prompt knowledge, service, and courteous, fair, and objective treatment at all times. So policyholders and claimants, right? I don't think that this is just reserved to us, but it certainly applies to work comp specifically, right? You are required to give prompt, knowledgeable service and courteous, fair, and objective treatment to claimants. If that doesn't tell you about your job being customer service, even to these people that seem like they're on the other side, then nothing will. It spells it out in black and white right there. An adjuster shall not give legal advice. That's where you defer to us. And shall not deal directly with any policyholder or claimant who is represented by legal counsel without the consent of legal counsel involved. We've worked around this for about 3 years ago. This is a real problem, figuring that out. I know that we had a DIR summit where there was kind of hotly discussed. I know that in a couple of these, Kevin was trying to figure out what he would say would be a bright line normal. There really isn't one, but I think that everybody's kind of settling and giving you the roadmap with. It's one of the positives to all the negatives with these long representation letters that we're getting, but they usually do give you in those letters, your direction. I think that most of, probably 90% of the market that's represented by attorneys, will give that to you. What I was gonna say is Kevin and I, right, are who you defer to.
Right.
Right. So if a client asks you for specific legal advice, and Kevin has said, yeah, you're okay to schedule, you're okay to deal with the doctors, set them up, let them know what the treatment is that they're going in for, all the stuff related to the medical, and they say, should I appeal this, right? Then you defer to counsel, which is Kevin, right? You can also defer to counsel, which is me, if they're not represented. What you should never do is tell them whether they should or should not appeal it, or even engage in anything from that conversation. You send it over to us, I've got the ethical standard for me as far as what I can say and can't say, and I'm going to be held to the fire on it.
So that
So in
just to piggyback that, Ann, because here's two things that I see. Again, this is just from my perspective, okay, and I've shared this before. Is adjusters have to be real careful because the unauthorized practice of law is a felony, okay. And now, does that mean we make a business of turning adjusters in for an unauthorized practice of law? Well, no, but I see it in sometimes two ways. Now, this is where I get back to talking about how adjusters who've been doing this a long time, you don't have to be a lawyer to know the law. You don't. But you do have to be a lawyer to give legal advice. Okay? So I'm not saying just I'm a lawyer and I know more. No, actually, claims adjusters that have been here a long time probably know more about claims than I do. Okay? Because that's what their job is. So I always, I think you should be careful there. The other thing too, be very careful when you send letters to a doctor quoting a law, okay? Because you are not a lawyer, and you need to be very careful because there's a reason why lawyers do that. And I often will see, and it goes nowhere, by the way, if that letter is not, if the law is not stated exactly how it really is and it's in the same context and all the type of stuff as if he and I would have sent it, it's useless because you're giving the doctor a law that doesn't exist, okay? And I cringe when I see stuff like that. Doesn't mean that everybody's wrong that does it, but I'm like, get your lawyer to do that.
Check the box letters are kind of going away, and here's the reason. Even if you explain the law to the doctor, you're asking for the doctor to apply a legal standard,
Right.
And doctors aren't experts at this.
They think they are.
I just had a case. We have a case that's probably going up to the Supreme Court right now, where that a appeals officer didn't recognize this. It was a last injurious exposure case, and they were asking for the doctor to construe as to whether it was related under the last injurious exposure rule to the first or second accident. Well, the doctor doesn't know how hard that it is to avoid when an injury is on the same body part. That's for a judge to determine.
Right.
And so it messed that case up, and it's probably going to get reversed. It's just not really the practice anymore to send those check the box letters that have the law written out in them. Always ask your attorney. I'll do, like I said, I do free consults. If you call me up, I'll give you a consult right there on the spot and tell you whether or not it's something that should be sent out to them. I'll tell you if it's legal advice or not and whether it needs to be on my letterhead. And that just is something you need to really worry about. 3 more, otherwise I don't think they'll give you credit. An adjuster shall comply with all local, state, and federal privacy and information security laws if applicable. Biggest place that we get into trouble here in Nevada and work comp is, like I said, you're an exception to HIPAA. Nobody else really is. A spouse, the employer, the insurer, the court, and counsel for those, and that's it. If somebody else gets a hold of that, if you have a contractor and subsidiary issue, you probably are going to be subject to a felony if you send out the medical information in a claim file to an employer that isn't the direct employer of your injured worker. So just be very careful about sending that medical information out. Just look at yourself like a doctor. If a doctor was going to break HIPAA by sending out this information, you have the same standard. You're just like a doctor who's exempt from it, but you can violate it, and you can violate that exemption. And if you do, then there are serious repercussions. An adjuster shall not have any financial interest. No bonuses based upon, no bonus strictly based upon reserves is basically what you have to understand that to be. If you keep reserves down, or if you short benefits, there's no bonuses based upon that. Bonuses and incentives based upon claim closures and everything that gets everybody. Those are the better incentives. Everybody wants claims to be closed, and to remain closed as long as possible. It means an injured worker has been treated and is healing. So, with all that, I did add a new slide just for Ann, as I promised her. That is the method for turning somebody in for violating one of these provisions. Claimants can turn you in. There's a enforcement arm to the Division of Insurance. You can have your license revoked or removed. I left a message at the DOI asking for them to call me back as to what the likelihood of that happening is and whether or not it's happened in the past. I don't know of it happening since we've started giving these lessons.
I've talked to him too, and I don't think, because that's the first time an attorney said, I'll sue your license.
Yeah.
I said, okay, I'll get back to you.
Yeah.
Because I wasn't real sure what that meant.
Yeah, it's
But
like
then once
real
I-
estate division. It's the
Yeah.
same. I actually made myself an account on it and tried to work through. It's a pretty intense
hard.
process to get through filing a claim against an adjuster And I used your name, so if something pops up, just let me know.
Oh my God.
I didn't finish the claim. I didn't submit it, but I used
They
that.
know my name.
Yeah, and so,
I know my name.
but the
I'm giving them a hard time.
but there, you could lose your license. You could lose your license permanently. They have to follow due process just like we do, but they have the power to be able to revoke your license, take it away, if something so egregious as this. They have specifics on the website, and we'll try to send out this so that you can follow the links. Frequently asked questions. They're very tailored to work comp specifically and to insurance at large. But they have frequently asked questions that talks about what they can and can't take away someone's license for, what a claimant basically or a member of the public should file a claim against. And so I'm sure that they take it seriously. They don't really market this, and so I don't think that most people know how to even file a claim. I had to do some digging to get through
I think
it.
it's all new. I think that it's something that we as administrators need to be aware of. That, and particularly those of you who hold adjusters, like my license is P&I license with a work comp added to it because I was a broker for a number of years. So depending on your license too, keep that in mind. What license you have, if it's a staff license or a P&I license with an add-on, because you're a professional. There's things they can do to make sure you do the right thing.
I think some adjusters are worried more or less about not necessarily like, hey, I know how to do my job and I'm not unethical, but coming onto a desk that hadn't been worked or was lacking in the work, and then they come on and they're hit with a mess. And then they're stressing to me and everybody, like, hey, what am I gonna do? Like,
You're just gonna
I'm
go
so
from that
backed
point
up.
forward,
I
because
don't
courts
wanna
aren't gonna
get-
hold you responsible
That's
for
what I
lack
said
of.
too, but
They're not going to.
I
But
don't
let
know
me
that
just
for
tell you-
sure,
I'm
so
gonna tell you
I'm-
a fast little story before we wrap up.
Yeah.
When I was a little kid in the business, I had an attitude. I know you're shocked. And there was a particular pain management guy here who did crazy stuff. And so I wrote him a letter that said, hey, I think you're doing this based on your motivation for money, not the patient. We still had bad faith. It did not go well for me. Because the next day, all of my assets were frozen. That man had filed a lawsuit against me, and everything of my personal assets were frozen immediately.
oh wow.
And those of you guys know I grew up under Chuck. I had to go to Chuck and say, hey, can you fix this for me? He did. But the lesson that I learned was, you're a professional. Don't say it. Just don't say it. Keep your mouth shut. Tell your spouse, tell your kid, kick the dog, do something like that. But don't say it out loud no matter what your thought is on that.
Hey,
And be thankful to God that we don't have bad faith anymore.
Well,
you have ethical, and not fully, but
Right.
the tide's moving that way. But you have ethical responsibilities. The reason that we go through all this to more than just yourself, right?
Oh,
The
very
angel and the
much so.
devil on your shoulder, they don't matter anymore,
No.
right? You have committed to an ethical responsibility, as those rules stated, to claimants, to your insureds, to your employers, to all these different folks. You don't have the luxury, and I say this doesn't, me and Dalton have issue with it, but you don't have the luxury of having principles a lot of the time. A luxury of being able to get off your chest what makes you angry, or hitting back and retaliating. You don't have that luxury anymore. At least the expectation is that you don't. And if that's where you're coming from, if you're getting back at all these claimants that are just committing fraud and just lying, then you need to take a step back. I'll tell you this much, I've heard from clients in the past, none of which are in this room, or I don't think any of which are on these calls, derogatory terminology based on race, based upon socioeconomic class, right? It's easy to develop stereotypes across the board. It's easy, right? In what we do, we see a whole bunch of injured people. We see a bunch of people that aren't injured that are spoiling the whole apple cart, right? But we don't have the luxury of harboring those stereotypes. We don't have the luxury of taking it out on the next claimant. You
Or
can be
saying it out
prosecuted.
loud.
You can be prosecuted, and more importantly, the industry will eventually reject you. It's still too small to get away with having a bad reputation. And
Well,
think about the
let me
next
just go
time.
back and reiterate that I was just kidding about the whole 22-year-olds don't work long hours. No.
Yeah. Right. No.
Let me just
No.
say, like, I totally stereotype those 20-year-olds.
If you're having a problem with competency, which everybody is, if you're having a problem with competency on your adjuster's desks, right, or you're seeing it, then reach out. We'll come and we'll train them. Our office will. I know that there's other offices in the state that will do that. And we'll come out and train them. We have resources. Every single adjuster before they adjust a claim should have read all of the statutes and all of the regs. There's no way around it. I have to do it every year. I have it on my calendar. I have to do it, and I'm in litigation every single day. And so if I have to do it, your adjuster should be doing it on a regular basis, but certainly before they begin adjusting claims. There's no way to.
I think we should have reg
competency.
tests for the supervisor, or for the adjusters.
I
think we should test them. I think we should, as an administrator and as a manager, I think you should continuously test them and have an open discussion as to how they apply.
Yeah, if you don't, you end up with the supply chain assembly line mentality,
Yep.
where they just start pushing it through. And what happens when the assembly line's a little bit off? Everything just goes crazy. You end up with 65 de facto denials on a hearing day, right? And that's. Listen, it's no one person's fault if that's the type of thing that's going on, but you're always in a position to be able to help to correct that. And if you need help, outside help, then we're here to help you. So,
Ask for it.
thanks everybody.
Cool. Hey, thanks for showing. Thanks for doing it.
Thank you.
And we so appreciate you two gentlemen. So appreciate it. Let's do some raffles.
Yeah, for sure.
We need the big
Get some
raffles.
water.
And yes, we have them for you guys
I forgot to fill
online.
back up.
Yeah, but only the gift cards will be online, because I mean, unless we, oh,
Right? And see, I understand.
I'm on Friday.
Next week, yeah.
No, this week.
The real case with the names are down. Kathleen is teaching.
yeah. Yes.
And you don't see it at all now. I suggested the other day that somebody calculate which manually. You'd have thought I asked them to do multiplication tables. They were praised on it. Oh, really? You did calculate? How do you know which one? You see spreadsheets.
All right, you guys, we're gonna start the raffles. We have a lot to get through, there's a lot here. So first one we're getting rid of. Amazon $50 gift card to, from TVJ Consulting. It's gonna be in person here. It's 315118. 315118. All right, next one is a $50 Sephora gift card from Dr. Colby Young, Jones, Fidel, Kochmeyer, and, oh, you got a new doctor, Dr. Gray?
Yes,
Oh.
specializing in complicated.
Stephanie Macy online.
That's good.
Awesome. Did I say who that was from?
I
did.
Yes, Dr.
Yes,
Young.
you did. All right. Next one is from Dr. James Manning, $50 Cheesecake Factory Outback Subway Carrabba's gift card. 315138.
Oh, that's me.
It's the birthday girl.
Happy birthday to you.
Next one is a $50 Ulta Beauty gift card from Laura Garney at Eagle One. Nanoska Martinez won this one.
Are they online?
Yes, Nanoska's online. Anybody commenting on that? Saying yay, I won?
I was looking at attendance.
Next one is a $25 Starbucks gift card from Hand Center of Nevada. Dr. James Vahey, Gluck, Miseb, and Herzog. Nicole Sartain, she was on. She was having connection issues this morning, so I know she's on. The next one is a $25 Dunkin' Donuts. All right, Nancy Borelli.
Has her name written all over
It
it.
has her name written all over it. This is from Dr. Vahey, Gluck, Miseb, and Herzog. Winning number is 315109. 315-109?
I think it might be mine. No, it's
315-109.
Oh, it is mine.
It is you?
Yeah.
Is this you?
Yeah.
Oh, no, that's not your, it's not my doctor. Yeah.
There you go, Nancy didn't get it anyway.
All right, next is a $50 Shell gift card for gas from Behi Gluck, Misev and Herzog.
We all need that.
Yes, we do. 315-114. Bye, Kevin, thank you. 114? Our next one is a $50 Target gift card from Advanced Prosthetics and Orthotics. Winning number, Bonnie MacArthur won that one. She is in Reno.
I'm going to Carson tomorrow, Friday.
Oh, are you gonna see Bonnie?
I'm gonna go.
Are you gonna go to Army?
I'm gonna go see CMSI, but I can drop it off.
Okay. All right, the next one is a $50 Shell gift card, gas card from Dr. Andrew Park. Winning number is 315-106. How did this happen? It's Laura again. It's got your Yeah, I know.
She has to put us in the thing in the last like 10
Hold on. We need to go to anybody yelling at me online? Stir
I
them up,
can do a
stir
box
'em up.
set, not on a single thing.
All right, we have a $25 Bath
So
and
it
Body,
is fair.
works from Capital Voc Consulting. Winning number is 315-147. I think that's mine.
It is.
It is me. Okay. I don't know, that's my own. Okay. I'll just put that in there. Winning number is 315033. Nope, this is online. Leticia Martinez wins Capital Voc. $25. What's his name?
Conflict of interest.
Oh. The next one is a $50 Kohl's gift card from AMG Hospital. Winning number is 315126.
That's me.
All right.
What's that? I want that.
You wanted Kohl's? The next one is a $50 Amazon gift card from Kelly Hawkins Physical Therapy. The winner is Aretha Parson online.
Woohoo.
All right. Next one is a $50 Amazon gift card from Behi Gluck, Misev and Herzog. Winning ticket is 315127. Is that you again? Sure. I swear, you see me, I'm shaking.
That was almost you. 1, 2, 4.
What happened?
1, 2, 3.
The next one is a $50 Amazon gift card from, what'd you miss? Oh, just my briefcase. Yeah. From TVJ Consulting.
That was on line 2. I got 2.
Winner is Sandra Arnold.
Thank you.
Sandy Arnold won yours, Trudy. Sandra. All right, next one is a $25 Ulta Beauty gift card from Vocational Rehab, Capital Voc. Marianne Carlisle. Online.
Isn't this Sandra Arnell? Sandra Arnell.
Yeah.
You said Arnold.
Oh, is it, it's not Arnold?
No, it's Arnell.
Arnell. Oh. Oh. Well, how many years have I known her?
I don't know. I'm surprised she didn't correct
She
you.
normally would, huh?
She's on the
Look, is she on right now? She's like, yeah, I'll correct you. The next one is a Lowe's, $50 Lowe's gift card from Dr. Gary Morris. Winning number is 315130.
No,
130.
I'm redoing my bathroom. It should be for me.
There's a Home Depot in here from Dr. Gary.
Hey, I need that. I need that.
The next one is a $50 Amazon gift card from Dr. Evangelista. Yeah. Dan Goldstick won this one. He sends Ella.
Yeah, I can take that to a
Oh, good. Okay, perfect. The next one is a $50 Home Depot gift card for Dr. Rod Berry. Ready?
149.
Sorry, Monica Wagner.
Oh.
Monica needs some housework. House stuff's done, I'm sure. Next one is a $50 Amazon gift card from Simon Med. Winning is Abril Perez Rodriguez, Amtrust.
I did it for my doctor.
Nice job, nice job.
Yeah, I think so.
All right, the next one is a $50 Amazon gift card from me.
I don't have that.
It's from me. 315144. Did I win my own gift? I won. I mean, cool. I'll no, it's not. 144. Anybody?
Even with that.
144.
Is that
it on.
I know it's coming.
And then all my
Amazon is already pretty good. All right, the next one is
it's a diffuser.
diffuser coconut lime verbena diffuser from Trish Gibson from Dr. Resident and a $50 Loft gift card. Winning number is Sabrina Walker. Sabrina, are you going to see? No, you're not. You are. Are you going to see Sabrina? No, she works from home.
Yeah, I have a gift, I have a packet for her from Christmas.
Our next one is a
Valentine gift.
Valentine little basket with a candle.
Don't nobody care about
It's
love.
like a bath thing. It's from IMA.
You and your 5 kids.
I don't love that. I'll say that.
So unfortunately, I don't think this person is in Vegas and we can't ship this.
What is it?
Cassie Puecti?
Oh, I don't know who that is.
I don't need
Is
it.
that liability or something?
It could be the liability from Indiana. So unfortunately, these two gifts we cannot do online, so I have to do somebody in person.
Is there no more
Ops just
gift
went
cards?
up.
No more gift cards.
Go for it.
David Martin, is David in Vegas?
David is at Sedgwick, I'm pretty sure, because he just sent me a.
That was in person.
He said I mean, if somebody knows,
Pretty sure you
then-
said in person.
I'm pretty sure he's in
Cancel
person.
the feed real quick.
Casey is in Vegas. Casey, we didn't call
I
him.
got
They
an
just
Not
email
volunteering.
this morning.
No, not Casey.
He's at
I'll
Sedgwick,
ask him.
Shannon
We have
says.
to take stuff to Sedgwick.
He's at
David
Sedgwick.
Martin is, yes.
We're awarding those people who show
But
up.
it's just getting.
Yes.
315100.
Oh, that's me.
Oh!
Who said it's me?
Right there.
She's an
Thanks to the people who are out of state.
Yeah. All right, the next one is also from IMA. It's another little Valentine's bag. Winning number is, these are all on, these green ones are online.
Yeah.
I mean, it would be okay if it was in state and we
Yeah.
could get it to them. Barbie Smith. Where does Barbie Smith work?
What's his name? I don't even.
I know.
I don't either.
You should look at this list here. So did Casey win? Because Casey,
Yeah,
she's in Vegas.
I know, but it's, we have to do in person.
I was fighting for you, Casey. It didn't work for me. Sorry.
I know. So Cynthia McGraw, I mean, I could bring it to her. If somebody knows David or Barbie or
Well,
Cynthia.
David has an email here, let me ask him. Barbie.
David's at Sedgwick.
It was just whoever's.
I know, but I hate to do that, and then everybody's mad at me on mine.
Oh, then get over it.
David's at Sedgwick.
There's all sorts of other things you can do.
We should,
They're not even there anymore, they've already logged off.
Yeah.
It's just a number.
Did you say all the ones that are online?
Normally I wouldn't know who David Martin is, but he sent me an email. from
315159.
Sedgwick this morning, so I know where he is.
159.
Thankfully.
All right, grand prize, we have a Coach bag, one left.
And we can ship that.
So I'm waiting for it.
We can ship it.
Christy, Sean's been waiting for this.
That's his Valentine's gift.
So this is from Craig Kinney. I am doing this.
She is Russian. She is. Oh, Sabrina says online only.
Oh,
You guys didn't know this before.
All right, ready? The winner is Jillian Christian.
Don't know who.
She's at Sedgwick, right?
All of us old people are just like, what?
No idea who these people are.
Sedgwick.
She's at Sedgwick. That's what Shannon just said.
Yes.
I'm pretty sure she's not with us
You
anymore.
already have.
Yeah.
Sorry.
Sorry, she's not with us.
I didn't do them because we weren't gonna go there. So now what do?
What?
We gotta figure this out because I feel bad for those online.
What do you mean?
Well, just in person. Do we give these away to only in person?
Yeah.
You can ship it.
I'm not shipping a person. It costs me $40 to ship it.
Only the physical.
Right.
Oh.
That's right. as we should do.
I guess if you guys want a coach purse, you have to come in for those. I'm being serious.
Yeah, that's right.
Hey, is that a legal opinion?
Yeah, I think so. I think we're good. I think you're good, yeah.
Thank you guys, we appreciate all that you did.
All right, 315-156, Coach Purse,
Still wait.
156.
So back here.
That was Bo.
Maybe we will drum up some more in-person attendees, because we had one adjustment.
All right,
And the last time we had one.
all right, if those online want to receive the Coach Purse, you gotta be in person.
Thank you guys,
That's
thanks for
everything.
joining,
Thank you so
we
much.
appreciate you.
Thank you.
Bye. Thanks, Craig.